Okay, my name is Jack Dearborn. This is the May 4th, 2021 Zoning Board of Adjustments agenda for this evening. We have 4 cases for this evening. I'll just read them briefly. Continuation of case number 13-2020, case 06-2021, case 08-2021, and case 10-2021. I'm the chairman of the zoning, chairperson of the Zoning Board of Adjustments, and I just want to kind of get everybody so they understand how we run the meeting. Some of you may not have been here before. So basically what happens is our procedure is such that I will first of all give an oversight on how we're going to run, how I'll run the meeting this evening. And basically it is, we'll start each case and we'll take the first one, in this case, in the order of the agenda, and that's fine. We'll do that one first, complete it to the end and rule on it, or it could be a couple of conditions. We can either approve it with or without conditions. We can continue it for cause. Could be that we need to say a site walk, or we might need to talk to the attorney or some other information we may not have this evening. We will always continue to a date certain, or if an applicant feels they need more time to bring information together that comes to light as a result of the hearing, they can ask for continuance. So, and then we can also rule that we will vote no with reasons so people understand why. So just so everybody understands, this is a court. It may be a quasi-judicial court, as it's called. It is the lowest court in the land as it comes to land use. And as such, we only hear cases that are properly filled out timely and filled out correctly. And anything else you might have for comments you feel is important, I'd ask you not to waste the time of the board and other people, because a lot of people on tonight, they like a timely hearing as well. And if you really have something that you think is important to share, I'd encourage you to share it with the select board. The select board appoints members of the ZBA for the 3-year term, or reappoints for a 3-year term. And it's all staggered. So we serve at the pleasure of the planning board, at the select board. And you can make a case that we aren't doing the job, or any one of us aren't doing the job, they can remove us for cause. So with that said, moving forwards, for a given case, I will read the application. We take them in order, one at a time. I'll read the application briefly, highlight what's part of it. And the first thing we do is accept the application. Now, what is that? That gives us a pretty good confidence if we can get 3 yes votes out of 5 members. We have 5 members tonight. We'll hear the case. If we find that it's not adequately supplied the information, we will make a determination, if need be, continue it in order to get the right information. The biggest thing is we don't want to hear a case that's not proper application. Should we find when we get into the case that there is an issue, stop the meeting. The board will decide whether we continue it for a good reason and say what that reason is, and then reschedule it for the next meeting. We have to schedule for date certain when we continue. So that's just the way we do it. So once I ask for a motion, and we always make the motions, we try to make the motions in the positive, meaning yes means yes, no means no. As a result of that, I'll ask for a motion to accept the application. For this evening, and because of this issue with Zoom and all that, I'm asking that, even though if he doesn't agree with it, if Mike Myers, the vice chair, will make a motion when I request a motion. And then Bobby Joe, if she will second the motion, even though she doesn't, she can always vote no, or Mike can vote no. It just allows us to administratively get through this. So to that end, if we have an affirmative vote, meaning 3 out of 5, you got to get 3 out of 5. It doesn't matter which one it is, who it is, to proceed. Once we got that, then I'll ask the applicant if they can come up. In this case, we will unmute the microphone so the applicant can speak. In the case of in case of any applications, we ask the applicant to read the question. In the case of a variance, it's the 5 points of hardship. Case of a special exception, which we have tonight, it's the 7 points of a special exception. So, and then read what is written in the form. And the reason is not everybody on the screen tonight or in the future will have what we have in front of us. So we want that information, which is what the testimony is, that we, as far as the variance go, we can only make a decision on the 5 points of hardship. They are prescribed by the New Hampshire statute, RSA 674-33, I believe it is. And those are the 5 points of hardship that a person must meet before a variance is granted. And like I said before, we can grant variances with conditions as well. So once we have the applicant before us, I will then ask the applicant to go through and read the question, all 5 individually, and give the answers. Then I will ask the applicant to mute their microphone, and then I'll ask if there's any approving abutters who wish to speak. Now, usually I see hands go up. I'm going to ask my ZBA members to look to see if I'm missing a hand that may want to speak. I don't want to, and everybody gets a shot twice, because I go through approving abutters, and we'll go through them until we get everybody satisfied first. Disapproving abutters will ask all those people to speak. Public at large, anybody wishes to speak. And you also ask for other boards. Should any boards be available that wish to speak, they may do it in an official capacity. Once that's done, I'll ask the applicant to come back, activate the microphone, and rebut anything that he or she wishes to say that was on the comments before her. After that, I'll ask them to sit down. I'll go through it one more time. Approving abutters, disapproving abutters, public at large, other boards. Everybody gets 2 shots at this. Okay, so if anybody's worried about any of those speak, they get two opportunities. Once that's done, we've gone through all the people that wish to speak at least twice. I will close the public hearing, so we no longer have a public hearing open to the public. And at this point, the ZBA will deliberate on the case. Each one of the 5 points of hardship have to be voted on individually. Ask for a motion, ask for a second. If conditions warrant, we'll put it usually on the first one because it carries. All the 5 points of hardship have to have at least 3 yeses. They don't have to be the same yeses for number 2, 3, 4, or 5, but they have to have a total of 3. If not, it fails and the whole variance fails. And that's the way it is. So I just want to reiterate again, we're expected to operate this in the fashion of a court. The whole purpose of doing that is it's predictable, and the person who's actually doing the minutes is really important that they get a clear understanding of what's happening in the meeting. Naomi's also taken minutes this evening as notes and such, but we really want to make sure we get the accurate documentation in place so we don't have to worry about what anybody said. So with that, I'm going to ask Naomi, which she may have already done, to turn everybody's microphone off with the exception of the 5 board members. And at this point, I'd like to ask Mike, please introduce yourself.
Michael Meyer, member.
Thank you. Bobby Joe.
Bobby Joe Plamondon, member.
Thank you. Mark Moretti.
Mark Moretti, member.
and Malcolm.
Malcolm Wright, member.
Thank you. Okay, at this point, because we only have 5 people tonight, all these 5 people will sit for all the cases that we hear this evening. So with that said, we can move on to the first case of the evening. This is a continuation of case number 13-0220. Application for variance from Gil and Shelley Duquette, 271 Quaker Street, tax map 404, lot 84, and residential district variance application is for Article 3, Section 3.5 and 3.51, which authorizes reduced setbacks. We have to interpret this as declared by the judge. There was a case here which the original interpretation was that lots less than the acreage in table 14.1 in the zoning are allowed to have less of a setback for frontage and less of a setback for sideline. Instead of 50 and 25, it was 30 and 15. But since the judge ruled that it only really applies to the actual dwelling and not the accessory building, we have to make sure that we ask for the application to be done appropriately. So here we go. Let me just go through this real quick. It's case number 13, Gil and Shelley Duquette, 271 Quaker, property address same, 1.62 acres, residential property, property lines described in the deed attached, garage for personal use. We applied for and got a permit in October 2018. Our neighbors argued that the permit was not legal and took it to court. The court reversed the permit. So that's why we're here this evening, and they're asking for a variance. And it's signed by, looks like Shelley Duquette. There was a checklist for compliance for an application. There is a butters, there's an application. It appears the 5 points of hardship are attached, and I will ask the applicant to read each question, then to give an answer. And then there is also here looks like there's a type as well. And there is a 5 points to hardship, and then there's a deed, and a court order attached. Court order, just for everybody's purpose, is Travis Cochran versus Jennifer Cochran, and Jennifer Cochran versus Town of Ware, number 216-2019-CV-00297. And it's signed by the judge. And Judge N. William Deckler, I guess it is. It was signed November 4th, 2020. Okay. Shelley, or Gil, I guess, whoever wishes to speak, if you will just say in a few words what your intent is.
Okay.
And then we'll go into the questions, and I'll ask the board before you get into the questions if they have any questions before we start.
Okay. As you stated, we are requesting a variance. In 2018, we did file for a permit, which was granted to us, and to build a garage with the setbacks of 30 feet from the road and 15 feet from the sidelines. That has been reversed. The permit was reversed. So we are requesting the variance to allow us to keep the building where it is, because we had built it based on the initial permit.
Okay, thank you. Any questions from the board of the applicant before we go into the 5 points of hardship? And which ones are you going to read, the handwritten or the
The
one
type.
that's typed? Okay,
Yeah, I kept the copy of the typed one at
Okay.
home.
you're welcome. Just want to make sure. So please read the question and your answer. And if we have any questions, we will ask them.
Okay. Let's see. So the first question is the variant, and I didn't copy all of the questions, but within it, I did say the variance, it asks about being contrary to public interest.
Mhm.
This variance will not be contrary to public interest because it's a residential garage. It's on our property. It's not going to increase traffic flow. It's for private use only, so it won't interfere with the neighborhood in that way.
Okay, and obviously a garage is a compliant use for a residential lot.
Yes.
Correct.
Okay. 2, please.
Two. Well, it's bigger than 2 place. Do you want the square footage of it? We didn't go by the,
No, you said number 2.
oh, I'm sorry.
Yeah.
I'm sorry.
Oh, I'm sorry, number 2. Question and answer, please.
Okay. And question number 2 is please describe how the spirit of the ordinance is observed. We're asking to utilize the section 18.2 for setbacks and frontage on the zoning ordinance. In that section of the zoning ordinance, they do say that this includes single family and 2-family dwellings, manufactured housing, and all structures.
Mhm.
The permit was reversed because 3.51 doesn't refer to all structures, 18.2 does.
Okay, so you want to, so you're asking to relax the 50-foot frontage to 30
Yes,
and the sideline from 25 to 15?
yes,
Okay. So when we make the motion, we will say no closer than.
okay,
You know what I'm saying? That's how it works, because if it's closer than 30 feet or 15 feet, you have a problem. So just make sure that's how we typically word these things.
okay.
Okay, 3, please.
Please describe how substantial justice is done because the benefits to the applicant must not be outweighed by the harm to the general public.
Okay.
Justice would be done because we went through the steps. We tried in good faith. We called before ordering our building. We thought we had accurate information because we called the town representative, and we did file for the permit legally. We went through the appeal 2 different times. And this, again, does not impact our neighbors. It doesn't impact the neighborhood with regards to increased traffic or noise or any other circumstances.
So generally speaking, most people with a residence has a garage
Right.
or can have a garage. So this doesn't violate it. The only issue in question that
Is
we're
the
here tonight
sideline.
is the
Yeah.
sideline.
Yes.
Very good. Okay, 4, please.
Please describe how the values of the surrounding properties are not just diminished. The properties are not diminished because it's built on our property and it's for private use. We know from real estate right now that things are really busy and selling quite easily, and that typically when a home estimate or appraisal is done, it's done on the actual home itself and not what your neighbors have in their yards.
Okay, so when you say there's a row of pine trees between the building and the road, you mean the front road,
The front road, yes.
the street? Okay,
Yes, yeah.
for some of it, right?
Yes,
Okay,
all along from the,
Wicker Street.
to the street, yep, right up to the driveway.
All right. And number 5, please.
Literal enforcement of the provisions of the ordinance would result in an unnecessary hardship. Please describe the special conditions of the property that distinguish it from other properties in the area, explaining the details of the property and structure that are different from surrounding properties, such as slopes and wetlands. The reason that we want it in that section of our property is because it was a flat area that was already cleared. We looked at the rest of our yard. That area is adjacent to our driveway. The back of our house has the leach field, which you're not allowed to drive over. And the other side of our driveway has our electrical lines, our well, our propane tank. There'd be several trees that would need to be cleared, and it's at the steep incline, which would require extensive excavation.
And I just want to make a point that in December, I believe, I don't know, maybe it was January, I think it was
It's December.
December, we had a site walk.
Yes.
And I think all the members on the phone tonight were present. It was set at 3 o'clock. We got there a little later. It's starting to get dark. We
just had the snowstorm.
Yeah, there was a bunch of other stuff, and it was very icy. So we took the time. We looked at the actual location of the garage. We looked at the hill, which would be downhill, looking towards Scott Ave, along the precipice where the obviously when the lot was cleared, it created a banking and went down over the hill. And then we also looked out to the where the septic system is and your kennel cage, I guess it is.
Yes.
And even the property behind you rolled off, so that if you took the 25 feet and you even put it at the 40-foot width, you would still have a substantial amount of a driveway to build, as well as substantial amount of fill, because there's no place to cut anything. It's at the height. So we did take a look at that, and we have minutes from that which have been approved. Okay. Let's see.
Okay. Owing the special conditions identified above, please indicate how no fair and substantial relationship exists between the general public purposes of the ordinance and the specific application of the provision to the property. Again, the garage is not going to interfere with public interest. It is for personal use only. No increased traffic or noise that would be new to anything that we have in our property.
Okay, and I please.
Owing the special conditions identified above, please indicate how the proposed use is a reasonable one. Explain how the special conditions of the property and the zoning restriction interferes with the reasonable use of the property. The request for the variance is reasonable because the town of Ware did approve the permit initially. The land officer had come up at the time and looked at the property and the markers prior to issuing the permit. The ZBA officers viewed the property during the appeal process and upheld the property, and the use is a garage on my property for personal use only.
Thank you. All righty. Any questions from the board before I proceed to abutters? I don't see any. So any approving abutters wish to speak to this application? Signify by waving a hand or something so we can see you. Whoever, Lynn Herrera, there we are. Mike, how you doing? You need to unmute yourself. There we go. Thank you. Good night.
How's that? Can you hear us?
Go ahead.
All right.
State your name, please,
This is Don Carrera and Lynn Carrera.
and where you live,
We live across the street from the Duquettes,
and your street number.
272 Quaker Street.
Thank you. Go ahead.
So I'd just like to say that I think the building permit or the variance should be approved. I agree with what Gil and Shelley have described, and they do have a row of trees that partially block the view of the building anyway from the road. And, you know, they have only 1.6 something acres. You know, where else are you going to put a garage on that piece of property? So from somebody who's right directly across the street, I don't see an issue with it.
Thank you. Any other approving abutter wish to speak? Do I see anybody? Oh, P. Prevention. Naomi, could you unmute her and him? There we go. Your name, please?
It's Pam Preventure,
And where's your location?
5 Quaker Street, right below Gill and Shelley.
What's your street address?
65.
Thank you. Are you no butter?
Yes,
On the abutters list?
yes.
I'll take your word for it. I'll check it, but okay. And
Jack, she is. She's at 265.
Correct.
okay, so it's 260. Okay, got it. Thank you. Okay, you may speak.
Yes, I approve them having the variance.
Okay,
Like Don said, there's not much property there for them to put a garage.
okay. Thank you very much.
You're welcome.
Any other approving abutters wish to speak? I don't see anybody's hand waving. No, okay. Okay, at this point, I'm going to open up to disapproving abutters that wish to speak. Recognize Travis Cochran.
All right. I'm going to read a statement, and I would request that the following statement and the survey of 271 Quaker Street that was done by Meridian Land Service and the full text of this testimony, including the footnotes, be added to the minutes of this meeting as an exhibit. The ZBA is in receipt of both an email and a printed copy of both this document and the survey a month ago.
Do we have a survey? I haven't seen it.
Yeah, I've sent it to you 5 times. I can send it a 6th if you'd like.
I mean, who did you send it to? Me personally?
The ZBA.
Oh, okay.
The statement begins.
Wait,
The illegal
wait,
building.
Travis, hang up for a second, please. I just want to make sure if we have it or don't have it.
I've got a USPS tracking code if that would help you to find it.
And no, it doesn't help me. I'm just asking Naomi if she sees it in her file, because we have not received it.
Well, you have received it. I've got a tracking code showing that.
Well, you didn't give it to my house, did you?
Well, I assume that you checked the mail for the ZBA, but I also CC'd it to your email address.
Well, it has to be an official copy through the
So,
town.
Jack,
Right,
Yeah.
and that's why I sent it to the town with USPS
Okay.
tracking.
Yeah.
Go ahead,
Yes.
Naomi.
I have it right here in the folder.
We don't have
It's
it.
done by Meridian for Travis, yes.
Well, we don't have it, so I don't know what it says. Will you able to throw it up on the screen, or is it just an eye chart?
I don't understand how you don't have it. I've sent it 5 times.
I'm
Jeff.
just saying, I don't think any members have it. It's not
Okay.
out of the package. I didn't know it existed.
Okay,
So I'm just saying, that's how I don't know it.
okay.
So
I believe
I don't
that.
know how the town knows it or not, so. We did
So
have a
in-
personal leave.
In the past, I've sent things to the ZBA at Town Hall. Should I send it to someone else?
No,
Okay,
because it's only official going through the town. We don't
okay,
have
good. That's the
private,
way I did it, so we're all set.
right, we don't have private files. It's
Right.
only through the town.
Excellent.
Naomi, can you bring that up on the screen to see if it looks like?
Jack, all I can do is show you. It was in the screen, it was in the file
Oh.
long before I took over.
You don't have electronic copy then,
I have a paper copy for the file.
but we don't have electronic copy you can put up on the screen.
I don't have that aptitude right now. I have it in paper. It was
Okay.
in the file before I took over the file.
Okay,
I don't know why you didn't get it. I'm just saying.
I mean, does anybody else get a
Here.
copy of that? No, it wasn't part of the application.
No, it wasn't part of the application. It was sent on 5 different occasions, though.
Well, not your application, I'm talking about Duquette's application.
Right.
Okay.
Okay.
That's official business. So anyways, highlight what you've got regarding the survey.
I've included it for your reference, and it shows the differences. And I'm bringing it up because at the site visit on 8 December last year, I mentioned to you face to face that you had a copy of the survey at that point, and
I didn't
I just
answer,
wanted-
did I?
I'm
I
sorry.
did not answer, and the reason is, the only reason to show up on a site visit is for the prescribed reason, not to hold a meeting outside the meeting, okay? I was very focused on that evening just to get the input.
Right. Unfortunately, you cut off the second half of my sentence. What I was saying is that the reason, the thing I want to highlight about the survey that Naomi has in her hands is that at the site visit, you were asking about the setbacks, and I, at the site visit, read out to you the actual setbacks from the survey, but you didn't want to hear those. You measured with a tape measure. So that's why I've sent a copy of the survey, so that in this meeting, we would have the actual measurements of the setbacks. But anyway, we
For
do
your
know that-
record, what are the setbacks as you understand it?
well, what the
you've
judge
heard.
said the setbacks were 50 feet from the front and 25 feet from the side. Is that what you're asking?
No, what are the actuals you believe Meridian did on the survey?
I don't have it in front of myself, but I believe that it was 32 feet from the front and 18.5 feet from the side. But whatever the copy in Naomi's hand says is the one that we want to reference.
And I showed slightly more than that.
Yes.
Right.
But anyway, so I
We'll
just want to make
accept
sure
the Meridians.
I accepted them. Yes, they're certified surveyors, so I
Yeah,
did accept
we'll
their
accept
numbers. Wonderful. All right. So the statement. The illegal building at 271 Quaker Street fails every prong of the variance test.
Are you going to read your entire document?
I am. There are so many legal issues and
Look,
Supreme Court precedents.
We have the entire document here.
Right. I know.
Okay, 21 pages.
Yep.
Um,
Well, Jack,
We've already
you know,
read this.
right.
What's the benefit of rereading everything again, other than
to
just
get it into the
torture?
record. Now, Jack, I would
It's
be
in the
amenable-
record. We have it here.
Okay. I would be amenable to condensing this. However, in the meeting, and I believe it was October 2018, you asked me if I could condense, and I tried to speed things up, so I did condense. But in that meeting, you then disallowed me to read certain parts of my prepared statement, saying that they weren't written down when they were. So given that previous experience, I really would like to make sure that every single Supreme Court precedent that is relevant gets read. So
It's here in
Yep.
the record.
excellent.
Okay, now, if you have something you'd like to talk about in this document specifically to amplify it,
Mhm.
I'm happy to entertain that. I just think it's just a lot. We got a long case tonight,
Yep.
and
It is a long case, and it's
Yes.
been delayed 3 times already.
Well,
It's
it
been
didn't-
before
that
the
didn't
ZBA
increase
for
any of
2.5
this.
years. So
Okay.
given that we've waited 2.5 years, I think another 15 minutes isn't too much.
you can't read the 20 pages in 15 minutes. If
In
you
fact,
can't
I
read
timed to myself, I can.
it. Okay. Just
All right.
we've got the document.
Yep.
Direct us to where you want to speak.
Okay. I'm going to start speaking at the first line. Introduction. The Duquettes have illegally built a 2,400 square foot, 25 foot tall steel building, 4,800 square feet, including the mezzanine level that they intend to build inside, that intrudes into both the front and side setbacks of 271 Quaker Street, despite being told ahead of time that it was illegally situated, despite being told ahead of time that the building permit was invalid, despite the town issuing a cease and desist order, and despite being told that the illegally issued building permit was being reviewed by the court. Having made the decision to violate several laws, the Duquettes now ask for forgiveness. However, they fail each and every prong of the 5-point variance test in RSA 674-33, and a variance cannot be issued. Prong 1, public interest. On the variance application, the question is, explain how the proposed use does not conflict with the purpose of the ordinance and how it must not alter the essential character of the neighborhood, threaten public health, safety, or welfare, or otherwise injure public rights. The Duquette's answer is, from their application, it will not interfere with the neighborhood. This does not address the purpose of the ordinance, it does not address the character of the neighborhood, and it does not address public safety or rights. In short, it does not answer the question. The burden of proof is on the applicant, and having failed to answer the question at all, the applicant fails this prong, and the variance may not be issued. The ZBA handbook explains, for the variance to be contrary to the public interest, it must unduly and to a marked degree violate the basic zoning objectives of the zoning ordinance. To determine this, does the variance alter the essential character of the neighborhood? What is the essential neighborhood character of the neighborhood? Quaker Street is a 250-year-old road filled with beautiful historic wooden homes with clapboard siding. There's not a single steel industrial building on the street, and certainly not one intruding into both front and side setbacks. And here, Jack, I will elide a little bit. Let me quote from the original appeal of the administrative decision back in 2018, which was upheld by New Hampshire Superior Court in November of 2020. I've researched the front setbacks of existing barns and utility buildings on Quaker Street. They are as follows, and there's a list from 76, 107.
How did you arrive at these?
We talked about this in October of 2018. The way
Just tell me now, for
right,
the record, this is, when you keep saying that,
right,
that was interesting, happened in 2018.
yeah,
It's today's case. That
right.
relevant.
Well,
Okay.
it's the same case.
It's not the same case. This is a variance.
Okay.
The other was administrative appeal. It's an entirely different
Anyway,
animal.
You asked Shelley was saying that it was effectively the same because she built it with that, but
You're not going to
no
win the point. What's your tolerance and how did you measure those setbacks?
right. I know that tolerances are important. You want to use the proper tools, and that's why we called in Meridian Land Survey for some of this, but this I did using Google aerial photos.
And what's the plus or minus on that? What
Let's
is
say
the
5 feet.
raster size on the screen? in
Let's say
terms
5
of
feet.
Huh?
What I've said is let's say 5 feet.
Why don't we say 20?
Okay, let's say
You
20.
don't know.
Yeah,
So
we don't.
basically you have an undefined number.
Right. I mean,
Okay.
to use Google Photos is often the direction of using a tape
So it's
measure
your
to
best
find a
effort.
setback. It's just
So it's
something
your-
you wouldn't do.
So it's your best effort?
Yes.
Okay, thank you. That's what I'm looking for.
Every single barn on Quaker Street meets the 50-foot setback in the zoning code, and the average distance from the street to an accessory building is 141 feet. Note further that every single barn on Quaker Street is a wooden structure averaging 1.5 stories in height, while the Duquette's industrial building is clad in corrugated steel panels and, at 25 feet tall, is 3 stories high. The Duquette's illegal structure that is 18 feet from the side property line and just 32 feet from the street line drastically alters the character of the neighborhood, and thus the variance cannot be issued. The fact that the structure alters the essential character of the neighborhood is corroborated by a report from Lou Manias of Capital Appraisal Associates, who writes, quote, I researched the heritage building that was erected, and it is advertised as a commercial and industrial building. This is not consistent with the uses and design of other outbuildings and barns found in your neighborhood, end quote. Lou's report will be discussed in more detail in point 4 below. The structure also negatively impacts public safety, as I'll also address in point 4 below. Prong 2, spirit of the ordinance.
So how does the public safety?
Right. So as I'll address in point 4 below. So if it's okay with you, I'll
Brought
just
it
keep going in
up.
order.
I want to hear it.
I did bring it up, and as I said, I'll address it in point 4 below.
I want to make sure I got it here because I got to
Great.
do it.
I'll remind you when we get to point 4. Just 1
You
second.
want to do it now?
No, I want to
Wasting
do it when
your
we get to point
15
4.
minutes. You're wasting your 15 minutes arguing with me. I asked you to specify.
You asked me
things,
to
do not.
speak of it, and I will speak of it, Jack. Prong 2.
What is it now?
Prong 2, spirit of the ordinance. On the variance application, the question is, please describe how the spirit of the ordinance is observed. The Duquette's text merely states that they want a variance, which has nothing to do with the question and is effectively blank. The burden of proof is on the applicant, and having failed to answer the question at all, the applicant fails this prong and the variance may not be issued. What does spirit of the ordinance mean? We look to the New Hampshire Supreme Court as quoted in the ZBA manual itself. In Maureen Bacon versus Town of Enfield, 150 NH 468, the ZBA denied a variance for a small propane boiler shed attached to the outside of a lakefront house because it would violate the spirit of the ordinance. Focusing on the spirit of the ordinance factor, the court concluded, quote, while a single addition to a house propane boiler might not greatly affect congestion or the overall value, the cumulative impact of many such projects might well be significant. For this reason, uses that contribute to congestion and overdevelopment would be inconsistent with the spirit of the ordinance. I want to call attention to 3 things here. First, the issue in Bacon versus Enfield was a setback issue. The setback was 50 feet, exactly the same as the front setback in Ware's zoning code that the Duquettes are violating. Second, the Supreme Court found that it was correct to deny a variance of that setback, not based on the impact of a single project in the setback, but based on a hypothetical case where many such similar projects were approved. So in keeping with that standard, the ZBA has to consider not just what the Duquette's 4,800 square foot industrial building infringing on both the front and side setbacks would do to the neighborhood, but what dozens of such buildings up and down Quaker Street, every one of them violating the front and side setbacks would do. Third, the Supreme Court said that a boiler, a simple 20 square foot box, 7 feet tall, would change the character of the neighborhood. The Duquette's steel industrial building, which is 40 feet wide, 60 feet long, and 25 feet tall, is 400 times the size of a boiler. If the Supreme Court has already ruled that a boiler in the setback would change the character of a neighborhood and thus does not meet the spirit of the ordinance standard, obviously the Duquette's industrial building can't remotely meet the standard and the variance cannot be issued. Prong 3, substantial justice. On the variance application, the question is, please describe how substantial justice is done because the benefits to the applicant must not be outweighed by harm to the general public. The Duquette's text merely explains that the courts overturned the illegally issued building permit. While I agree with them, the court did overturn the illegally issued building permit. This has nothing to do with the question, and failing to describe either benefits or harms is effectively blank. The burden of the proof is on the applicant, and having failed to answer the question at all, the applicant fails this prong and the variance may not be issued. It is not the case that the Duquettes have an inalienable right to build a second building on this land, and the ZBA is here to figure out how to justify it. The Supreme Court explained this in Oimet versus City of Somersworth, 119 NH 292. The hardship alleged by the defendants is that they cannot expand. Reliance on these factors to support a variance reflects a fundamental misconception of the function of the variance. And then bolded, the inability to use land for one particular purpose is irrelevant to whether a variance should be granted. To apply that to this case, even if the setbacks and Ware's zoning code made it impossible for the Duquettes to use their land for a particular purpose of having a steel industrial building, that would be irrelevant to whether a variance should be granted. The Duquettes have had full use and enjoyment of their land for 17 years without a steel industrial building, so obviously a steel industrial building is not critical to their well-being. The good news, though, is that the Duquettes can fit a structure on their land while obeying the setbacks. Mr. Duquette himself admits this, as I'll get to in a moment. The preceding points show that the proposed variance fails the substantial justice prong, and thus it is not necessary to examine the ratio of the benefits to the Duquettes to the cost that they seek to impose on others. But if we do so anyway, we see that the cost to others, covered in depth in the next section, are much larger than the benefits to the Duquettes, which are zero, given that there are other locations on their property with very gentle slopes where they could build legally with only normal, customary, and expected construction expenses like logging and grading. Prong 4, the value of the surrounding properties are not diminished. On the variance application, the question is, describe how the values of the surrounding properties are not diminished. The Duquette's text does not answer the question and merely states that, quote, there is a row of pine trees between the building and the road. The implication is that the building is an eyesore, but that it's hidden. That's half right. The building is an eyesore, but it's exceedingly visible from the road, and it's even more visible from my house because the Duquettes cut down the trees that used to be along the property line. The Duquettes have presented no proof of their assertion that property values are not diminished. The burden of the proof is on the applicant, and having failed to answer the question, the applicant fails this prong and the variance must not be issued. The value of my land would be greatly diminished in two ways. First, the diminished curb appeal and visual impact from the blight caused by the industrial building diminishes the market value of my home. Lou Manias of Capital Appraisal Associates did a study and concluded, I believe, in the absence of an exact duplicate of your situation, that it is appropriate to rely on other market-derived information. Based on the 4 sets of sales analyzed, loss of market value indicated is from 3.15% to 13.25%. The median of all the data sets analyzed is 4.69%, and the average is 5.63%. Applying this to the town's current assessment of my property, plot 404-86, we see a loss of market value of between $16,319 and $68,644, with a median loss of $24,297 and an average loss of $29,167. Second, the maintainability and safety.
Where is, are you just reading that, or do you have it in this package right here?
I'm reading it.
Oh,
the
well,
packet.
so are you gonna hand us a copy of that?
Yes, I did to your person in December, and then I mailed another copy 4
I got
weeks
it
ago.
right in front of me, right here, the person.
Okay.
So where is
I've
it
got a
in this
USPS
package?
tracking number showing that this was
No,
received.
no, where is it in the package? What page?
Approximately page 4 or 5. If you follow along, I'm just going straight in order.
I have been, but I
Okay,
didn't see
great.
these percentages or anything like that you're talking
Well,
about.
then you're dealing with the out-of-date one that I handed you in December, not the one that I mailed you 4 weeks ago today.
This is the one that's handled, that happened 4 weeks ago.
Okay. Well, so you're telling me that you're looking at the one that you got 4 weeks ago and you can't find.
No.
So look for the bold text that says prong 4, please.
Yes, and that is on prong 4, right here.
Great. Now go to the
Go
next
to the flip the
page,
page.
or go to the bottom of the
Kelly's
page.
text does not answer the question. You put a bunch of percentages out there and I don't see that information.
Okay, so you're not looking at the current version that you received 4 weeks ago, Jack.
Well, I'm saying this is the one that came in the mail.
Okay, well, I've got a USPS tracking number showing
Mike,
that.
can you tell that? Mike, can you
Jack,
tell if?
Jack, you were
can
saying
find-
earlier that we're short on time. Would you like to move along?
No, I just got to make sure that what you're
Okay.
saying is
Yep.
trackable.
No, I agree. We should take the
It's
time to do this
interesting.
right.
But I just need to make sure it's factual.
Okay.
Can we lose somebody? Go ahead. Bobby Joe?
Would you like me to take 60 seconds to email you a copy of the report?
No.
Okay.
Naomi,
I was just,
I just wanted to add that I have both copies from before and the one 4 weeks ago, which are
Excellent.
exactly the same. I looked at them before and they're exactly the same and do not have a lot of what you're reading, Travis.
So.
Okay, so I guess it's a good thing that I'm reading it because we've got the new section here.
Well, again, okay, then you have to hope that we record it correctly. We don't have it in front of us. Okay, just
Well,
want to point it out.
Right.
Okay.
And I'll point out that I've got tracking information showing that you received it.
Well, that's very interesting, but both copies, one you gave me physically and
Right.
one I received 4 weeks ago, whenever it came in, are exactly the same.
No, that's not correct.
Well, I'm just telling you what we have.
Okay,
Maybe they
I
copied the
believe that
same
you've got
one
two
that's
copies
wrong.
of the same thing, Jack.
You're wasting your time. Where would you like to go now?
I'm not pausing at all. I actually asked if we can move along, but you didn't want to. So anyway, I'm happy to continue now.
Just so long you understand, I keep the clock.
Okay,
You have an opinion, okay?
okay.
Go ahead.
Based on the 4 sets of sales analyzed, the loss of market value is from 3.15% to 13.25%. And then I worked out the numbers and that this is a loss of value between 16,000 and 68,000. Second, and this is the point that earlier you wanted to talk about safety. Second, the maintainability and safety of my home would be impacted and has already been impacted. The illegal structure drastically alters water flows because of 4 design decisions: the impermeable roof, the ground between the structure and my property line, which Mr. Duquette contoured away from his structure and towards my property, the lack of French drains, and the impermeable perimeter foundation. Before the structure was built, precipitation that landed on the Duquette's yard soaked into the permeable soil, which is soil type 76B, Marlow Fine Sandy Loam, according to the USDA NCRS Web Soil Survey, and then flowed down a 4% grade to the east, according to the 2-foot LiDAR topographic map at graniteview.unh.edu. After the structure was built, 2,400 square feet of absorbent soil was covered with metal roofing, and the precipitation that lands on the western half of that roof is now discharged just 18 feet from my driveway. Because the Duquettes contoured the ground around the structure to move water away from the dirt floor inside the structure and to the west, that water is actively directed towards my driveway. Because the Duquettes did not install French drains, that water is now routed to the east. Because the Duquettes built a solid 4-foot deep concrete pure perimeter foundation that parallels my driveway for 60 feet, the water cannot passively flow to the east. Instead, that water, plus the water that lands in the 18-foot by 60-foot space between the structure and the property line, is directed west into a small portion of my driveway.
Let me stop you there. That's an important point. So Meridian did not do an elevation on your driveway, on your top of your gravel grade to the top of the dirt that's over on the other side.
Right, but
You're
Jack,
relying on- you're relying on
if you're
Google
concerned
Maps,
about
right?
topographic maps, you do have a topographic map in your possession from
Yeah,
Bruce
but it's plus or
Stillmore.
minus 20 feet or 10 feet. You can't get the granularity. I stopped by the other day and purposely looked to see this. I did not get out with a level, but it appeared to me that your driveway is higher than that.
So wait a second, Jack,
suggesting that it's
you
flooding?
stopped by because you wanted to see the slope issue. That was not called out in the
No.
December-
I stopped by just the other day when
Yeah.
I read this 18 feet dirt and all this slope.
Oh, so that's excellent. So you do have the most recent copy of the document. That's the one.
No, I don't. I
But
said
but
I
that's only-
physically stopped by.
Right, but Jack, what I'm saying is you said you physically stopped by because the document you had in your hand said 18 feet.
It
That-
says 18 feet right here.
Right, exactly, in the most recent copy. So you do have the most up-to-date copy. So that's good
No, I
news.
have at least a page of the up-to-date copy.
Right,
that
excellent.
paragraph.
Right, so
I'm-
excellent. So you've got the
I'm
up-to-date
playing
one.
this
I'm thrilled.
game. Apparently you got different information than the rest of us do. We
Okay,
got 2 copies out of you. Okay,
right.
we're
Well, I
approaching
gave you the
1
one in
minute to
December
go.
because I
Where
thought
do you
we were
want
going
to
to have a
spend your
meeting in
minute?
January.
Where do you want to
So-
spend your minute?
I'll continue, please.
Well, it'd be better if you want to continue. Get ahead. get
Where
going.
gets 38 inches of rain per year, so this combination of impermeable roof, lack of French drains, land contoured to shed runoff towards my property, and impermeable perimeter foundation results in an additional 7,220 cubic feet or 54,000 gallons of precipitation per year being directed into my driveway. To give a sense of scale, that's the equivalent of a 500 gallon per minute fire truck pump running for an hour and 45 minutes. The water floods the adjacent section of my driveway and runs down the driveway to the south, doing additional damage well beyond the area next to the illegal structure.
Again, all you just said isn't in our document. Go ahead,
A
continue.
dirt and gravel driveway that was installed by Harry Weatherby, a trained geotechnical engineer, and which served him well for 7 years, and which served me well for 6 years, has been turned over the last 2 years into a muddy swamp with ruts over half a foot deep. This has 3 effects. It means that it becomes much harder to use my driveway during wet weather. It means that my driveway suffers much more rapid damage that I have to repair. It means that a safety issue has been created where town emergency vehicles may not be able to navigate my driveway during wet weather, but may become bogged down in deep mud. I lost a muffler to the driveway damage just a month ago. That's several $100s of loss caused by the Duquette's illegal structure. 2 weeks ago, I had to spend over $500 to add 18 cubic yards of gravel to my driveway just to temporarily repair it so that I could leave my house. Luminice's report speaks to this, saying, I spoke with several contractors who indicated that to cure this issue on your property alone, the area alongside the sides of your driveway and perhaps the driveway would have to be excavated in order to put in a drainage system that would include a sand and rock base, perforated piping on both sides of the driveway to collect water, and perhaps even a culvert if it considered necessary after site design and engineering were completed. It would also include regrading of the driveway and mixing the existing soil with other material to make it drain better. The cost estimates for such an endeavor ranged anywhere from $20,000 to $40,000 and could potentially be higher. End quote. If we add together the high-end market value impact caused by the visual blight and the higher of the two estimates for drainage remediation, we end up with a total impact to my property value of $108,000. If we instead use the averages of both numbers, we still end up with a total impact of exactly $60,000. The fifth and final prong, hardship. On the variance application, question 5A asks, describe the special conditions of the property that distinguish it from other properties in the area. The Duquettes do not answer this question, but merely provide a sketch of the property that is out of scale, implies that their leach field is an acre in size, and does not include half of their property. They describe no special conditions, and the answer is effectively blank. I agree with the Duquettes. There are no special conditions that distinguish their property from others in the area. Question 5A-Roman numeral 1 asks, owing to the special conditions identified above, please indicate how no fair and substantial relationship exists between the general public purposes of the ordinance and the specific application of that provision to the property. The Duquette's text says, the building was put up on clear level land. This is not an answer to the question and is effectively blank. Question 5A-2 asks, explain how the special conditions of the property and the zoning restriction interferes with reasonable use of the property. The Duquette's text says, the town of Ware did approve the permit. Yes, it did. And the courts ruled that the building department violated the law in doing so. This is not an answer to the question and is effectively blank. The burden of the proof is on the applicant, and having failed to answer the questions, the applicant fails this prong and the variance may not be issued. 5.1, cause of hardship, violation of C and D. The Duquettes state they want their variance because they've already built the steel industrial building. Shelley said that at the beginning of this meeting. This is proof, in their own words, that is not literal enforcement of the zoning code that is causing hardship, but the Duquettes' own violation of a cease and desist order that is doing so. The zoning board is not empowered to grant variances that relieve hardship caused by violations of cease and desist orders. 5.2, a permitted use, not all permitted uses. The ZBA manual says on page D6, if the land is reasonably suited for a permitted use, no hardship can be found. Note the word a, the singular article. The full list of permitted uses is found in the Ware Zoning Code, Article 17.2. The Duquette's parcel is in fact suited for a permitted use, specifically the use of having a house on it, which is listed in 17.2.3. Since the Duquette's land is reasonably suited for the permitted use of having a house, no hardship can be found. This argument has been upheld by the Supreme Court. The ZBA manual references the case of Crossley versus Town of Pelham, 133 NH 215, which is very similar to this case. The Crossleys, like the Duquettes, had a house on a non-conforming lot and wanted to build a second structure, a two-car garage, presumably about 400 square feet, much smaller than the Duquettes' 4,800 square foot industrial building. The ZBA manual summarizes the case. Landowners went before the Pelham ZBA for a variance to replace the one-car garage on their non-conforming lot with a larger two-car garage. Neighbors appealed the granting of the variance to the Superior Court, claiming that the requisite unnecessary hardship did not exist in the case, where the landowners simply wanted a larger garage. The Supreme Court noted that the hardship cited was a result of the landowner's personal circumstances, that a one-car garage or even no garage would still be a reasonable use consistent with the ordinance, and that therefore the Superior Court erred as a matter of law in finding unnecessary hardship supporting the grant of a variance. Let me repeat that last point. A house that has no garage at all is a reasonable use of land, and therefore it is an error of law to claim that hardship exists if literal enforcement of the zoning code entirely forbids a garage on a certain parcel. This is exactly the fact pattern before us, and the Supreme Court has already ruled on it. The ZBA cannot overrule the Supreme Court.
What's the date for all these rulings
Right.
relative to what criteria for the zoning board?
The date of that
5.9.
ruling is 1990, and you can find it in the ZBA manual. So it's
There's a
current.
problem there because the criteria for variances changed significantly in 2010.
Okay. So this is in the current copy of the manual for the zoning board, which, you know, I'm sure you're
whose manual?
the state of New Hampshire.
It's the friendly advice to help people manual. I got it. I understand.
Okay.
It's not-
So are you unfamiliar with the ZBA manual, Jack?
Oh,
Should I
I'm
give
very
you a link?
familiar with it.
Okay,
I'm just
great.
suggesting that the cases you may be citing may have been overcome by events.
Okay,
Please continue.
okay. Alternate locations, the other reasonably feasible methods test. The hardship test has two subprongs. One is other reasonably feasible methods. If there are other approaches consistent with the zoning code to achieve the goal, no hardship can be found. The first Google hit on buildings and grades at buildingadvisor.com says that, quote, gentle grades of less than 10% are the easiest to build on. Between 15% and 20%, you should plan on spending a little more on grading. There are many locations at 271 Quaker Street with grades between 15% and 20% where the Duquettes could build legally and easily. I brought maps showing 6 of these locations where they could build a structure of exactly the size and shape they want to the ZBA on 5 March 2019, but unfortunately the ZBA refused to view them. There's one particular location, 127 feet from the front boundary and
Wait a
25
minute.
feet.
We refuse to do what?
You refused to view the maps that I brought on 5 March 2019. But it doesn't matter. I can skip past that if you're not.
What year?
2019.
Oh, different case, right?
Well, it was 271 Quaker Street.
It's a different case. This is
Okay.
a variance.
Great. I'll defer to you, Jack.
Well, I'm just.
There's one particular location, 127
Keep going.
feet. There's one particular location, 127 feet from the front boundary and 25 feet from the east boundary, where a building of exactly the size the Duquettes want could be built on a very shallow 10% grade, quote, a gentle grade that is easiest to build on. I was hoping to show this location of the ZBA on the 8 December 2020 site visit, but unfortunately the ZBA chair refused all 3 of my requests. Finally, we know that it's possible to build on the eastern portion of the parcel because it's already been done. There's a foundation of an old building there right now. If building on the eastern portion of the parcel is possible with 19th century technology, it is possible with 21st century technology. Given that there are other reasonably feasible methods to accomplish the goal, the applicant fails the subtest. Special conditions of the property, the unique in its surroundings test. The second subprong of the hardship test requires that, quote, the applicant demonstrate that the property is unique in its surroundings. Garrison versus Town of Henniker, 2005. The application notes that the front yard has electrical wires and trees that would need to be cleared. And this is a point that Shelley brought up early in her application. She listed the problems with other locations, that there are power lines, that there's a propane tank, and that there are trees. Presence of electrical wires is not a unique special condition of the property. The Duquettes' desire to avoid paying the electric company does not justify a variance. Likewise, the presence of trees is not unique in the state or even on Quaker Street. The Duquettes' desire to avoid paying loggers does not justify a variance. Finally, land that is not perfectly level is not unique in the Granite State. Yes, there are portions of the parcel that have a noticeable slope, but there are other areas of the 1.6 acre parcel that have grades of 15%, 10% or less. The Duquettes' desire to avoid paying for 1 day of bulldozer service does not justify a variance. I note that the location mentioned above, 127 feet from the front boundary and 25 feet from the east boundary, has a 10% slope. It is common in Ware to build on a 10% or even on much steeper slopes.
So this
Houses
is
on-
material that you haven't given us, right? This is.
No, I did give it to you. I've got a tracking number showing that you got it about 4.5 weeks ago. So anyway, to continue, it is common in Ware to build on 10%.
How much
or even on-
longer? You're out of time. You're about to be done with number 5, I believe.
Okay, yes, there's just one paragraph left.
Go ahead.
It is common in Ware to build on 10% or even on much steeper slopes. Houses on Cortland Ave and Ware were built last year on steeper slopes. Houses on Duck Pond Estates and Ware are being constructed on steeper slopes as we speak. Closer to 271 Quaker Street, I note that the barn at 76 Quaker Street is on an overall 12% grade and parts of it are on a 20% grade. Portion of the Duquettes' own house, in fact, are built on 23% grade, as evidenced by the house's walkout basement. The applicant has not demonstrated even a single special condition of the property and thus fails the subtest. You do not have to trust my maps or the 2-foot resolution topographic LiDAR GIS data. You can trust Mr. Duquette himself. Mr. Duquette stated on 15 September 2020 in court and on the record that there are other locations on his property where he could fit his building. This is in the transcript on page 37 of Travis Corcoran et al. Plaintiffs versus Town of Ware Zoning Board. This is quoting Mr. Duquette. We did have other spots that we were looking at, but we would have ended up having to move the power lines. We would have had to move my propane tank. My well would have been right in the middle of the doorway of the second garage door. So it absolutely made no sense to continue to go there where the site where it is now was completely clear. It was the most cost-effective way. Note that Mr. Duquette said spots, plural. Mr. Duquette could have cited the building in one location, but didn't want to because he would have had to move his propane
That's a
tank.
long paragraph.
That was section 5, I was saying, and this is a different section. But anyway, if we can move along. Mr. Duquette said that he could have cited it in a second location, but he didn't want to because he didn't like the aesthetics of his wellhead being between the 2 doors of his building. Mr. Duquette said that he could have cited it in a third location, but he didn't want to because that would have cost him a bit of money to relocate a power line. Mr. Duquette has gone on record in court and said that there are other locations where his building would fit. The Duquette's desire not to spend $200 to have Suburban Propane move his tank, recall his words, quote, "It was the most cost-effective way," does not create a hardship that lets the ZBA overrule the zoning code and destroy $60,000 to $100,000 of my property value. The Supreme Court has ruled that if other approaches to the same goal exist that do not require a variance, then there is no hardship. Mr. Duquette has other approaches to the same goal. He has said so himself. The ZBA cannot overrule the Supreme Court.
Thank
The
you.
members of the ZBA, and this is the conclusion now, the members of the ZBA are human, and I'm sure that
You're
they feel
talking about
bad.
the feeling bad?
Yes, and I'm
Do
sure that
you
they
feel
feel bad.
this is important?
I do, and I'm sure that
I'll
they
let you
feel bad.
go.
And I'm sure that they feel bad for the situation that the Duquettes are in. However, it is important to remember that the Duquettes are not in this position because of the zoning law. The Duquettes are in this position because they chose to ignore the town and chose to violate the law. And Mrs. Duquette said at the beginning that she wanted a variance so that she could keep the building where it is, and recall that the building was built in violation of a cease and desist order. In November of 2013, I was about to make an offer on what is now my house. To make sure that my investment would be protected, I read the zoning code from start to finish and identified correctly, as the court has pointed out, that the setbacks on both my land and on adjacent lots were 50-foot front and 25-foot side, and saw that those could only be reduced for the construction of a primary residence, a term that is defined in the zoning code, because I knew that the zoning code would protect my property value as I purchased my house. On 8 October 2018, before excavation started, I saw stakes in Duquette's yard, and I informed Mr. Duquette that his proposed location violated the zoning code. Mr. Duquette ignored this. I returned with the zoning code with the setbacks circled in red. Mr. Duquette ignored this. On 11 October 2018, I emailed Mr. Duquette and asked him to attend the planning board meeting. Mr. Duquette ignored this. On 12 October 2018, I emailed Mr. Duquette and offered to pay for his logging so that he could situate the structure legally. Mr. Duquette ignored this. On 24 October, I emailed Mr. Duquette to ask to meet him face-to-face so that I could reiterate my offer to pay for logging. Mr. Duquette ignored this. On 1 November 2018, I emailed Mr. Duquette increasing my offer to pay not just for logging, but to contribute towards new excavation. Mr. Duquette ignored this. On 3 November 2018, I walked down my driveway to contact Mr. Duquette, make sure that he'd received my email, and to reiterate my offer. Mr. Duquette ignored this and instead chose to scream F-bombs at me for 15 minutes and said that my objections didn't matter because building officer Chip Meany had told Mr. Duquette that they would give Mr. Duquette a variance no matter what the code said. On 7 November 2018, I emailed Mrs. Duquette reminding her of my offer to pay to relocate the building. Mrs. Duquette ignored this. On 5 March 2019, knowing that a cease and desist order was in effect, Mr. Duquette ignored this and continued construction, beginning work on a sonotube foundation. On 15 April 2019, Mr. Duquette received a letter from Tarbell and Brodich telling that a case was pending, that he was building at his own risk. Mr. Duquette ignored this. On 4 September 2019, the court in town gave notice to Mr. Duquette that a court case existed regarding his illegal structure and inviting him to join the case. Mr. Duquette ignored this. On 19 October 2019, knowing that there was a pending case before the court, knowing that a cease and desist was in effect, knowing that a sonotube foundation had not been inspected and that thus construction was doubly illegal, Mr. Duquette ignored this and built the frame of his illegal structure in the setbacks. On 15 December 2019, knowing that there was a pending case before the court, knowing that a cease and desist was in effect, Mr. Duquette ignored this and built the roof of his illegal structure. On 15 February 2020, knowing that there was a pending case before the court, knowing that a cease and desist was in effect, Mr. Duquette ignored this and built the walls of his illegal structure in the setbacks. I'd like to quote the town's legal counsel, Attorney Drescher. Actually, this isn't Attorney Drescher. Right, this is Attorney Drescher's father, who said the following in court on 15 September 2020 regarding the Duquette's case. I've often advised my clients that when an applicant is appealed to the court, application is appealed to the court, and the property owners go ahead and start building in spite of that the town should write them a letter and say, you're doing this at your own risk. And if it turns out that you lose this case, you're going to rip it down, and we're going to be the ones that are going to make you do that. This is not my attorney. This was the town's attorney, second attorney. The town did exactly that. They told the Duquettes not to build with a cease and desist, but the Duquettes ignored this and built anyway. The Duquette's choices, not any characteristic of the land at 271 Quaker Street, which is what a variance requires, are why they're in this situation. The ZBA may feel bad for Mr. Duquette, but the ZBA handbook says clearly on page 2-10, the board does not have the discretion to grant the variance because they like the applicant. And final 2 paragraphs. The ZBA manual says the applicant has the burden of persuasion on all 5 variance criteria, page 2-12. The Duquette's application has not provided arguments for any of the 5 criteria. Even if I didn't say one word tonight, Mr. Duquette has failed to make his case for a variance on each of the 5 prongs. But in fact, I've actively proven that this variance request fails on all 5 criteria, and I've cited New Hampshire Supreme Court precedent. Additionally, Mr. Duquette himself said in court on 15 September 2020 that there are locations where he could build a steel structure legally. He chose not to. By his own testimony, Mr. Duquette has ruled out a variance. Voting in favor of this variance would not give Mr. Duquette relief. It would only drag out this process through several more years of court cases. The laws are clear and they will be enforced before this process is done. The town of Ware has already lost 1 court case on this matter. Granting a variance today would increase the cost to Ware taxpayers, but it will not change the eventual result. A variance cannot be legally granted. The town government has already spent $20,000 of taxpayer money trying to defend an indefensible violation of the zoning code. There is no reason for Ware taxpayers to incur the cost of continued litigation when the result is dictated by binding Supreme Court precedent. The ZBA must deny the variance. Thank you.
Okay. I just want to make a point that what we have on file is not consistent with the total testimony. So we'll have to rely on the video. The
I'll send you a
audio.
copy by email right now, Jack.
It doesn't matter. It's not me. It's the town of Ware that has to receive it. You think somebody's going to bring something to a court of law, email it in? It has to come in through the proper process.
Okay, so are town of Ware email addresses proper process? They have been in the past.
You should talk to the people in the town of Ware.
Okay, the answer is yes, they are.
Well, you're welcome to your opinion.
Okay,
The
Thank you.
problem is we don't have it in front of us. We
okay.
got two
I don't know whether
shots
you've
at
got it in front of you or not, but I've got the tracking code showing that it was received.
Well, so noted, you got the tracking code. It doesn't help the fact we don't have it.
Okay,
Irrespective, it's not necessarily your fault. I'm just making a point.
okay.
So we're gonna have to rely on your verbiage that you spoke this evening. Okay. With that said, is there any other disapproving of butter who wish to speak? I'm looking for hands. I don't see any. I don't want to short anybody out here. Public at large that wish to speak? I see one hand, Laurie Davis. Just a second, Laurie. We'll have to flip the switch so you can speak. There
Are
you
we
go.
okay?
Laurie, your name, please.
Lori Davis, 118 Buxton School Road. I have been involved in taking real estate classes,
Mhm.
and I'm a property owner. When a town ends up in court and it costs taxpayers money and people have received a cease and desist, and they do not obey the cease and desist, it's going to cost the taxpayers more money to deal with this. Rules are made for everybody. And when you request a variance, it's not because you don't want to spend the money. To say that they can't put this building in their backyard, they already have vehicles back there that they've got stored behind a fence. So the leach field isn't the problem. But as far as property owners' rights and protecting the value of your property, it does devalue the property. He no longer has a sight line that is pretty. And if we continue down this slippery slope, everybody else has to follow the rules. But, oh, I ignore all the rules and I put up a building and now we're going to put in a variance. That's wrong. Thank you.
Thank you, Laurie. Are there any other publics at large that wish to speak? I see a Michael O'Day. We'll turn your mic on in a second.
All right. My name is Michael O'Day.
And where do you live, Michael?
I live at 52 Chase Hill Road,
52. Jeez. Okay, thank you.
and I'm speaking in opposition to the variance, as has already been noted. This is going to cost the town a lot of money to fight in court. I have no interest in spending taxpayer money on fighting this in court. We just recently had an election where this issue came up for a public vote and it was soundly rejected. And I see no reason to be continuing this any further. Thank you.
Thank you. Okay, other boards wish to speak?
We've got one more, Jack. I think John
Oh, I'm
Rasher.
sorry, I don't want to cut anybody out. Who would like to speak? John? Go ahead, John. Please turn John's mic on, please, Naomi. Where are you? Not yet. There you are. Okay, John, name please.
Rauscher, 273, John Rauscher, 273 North Stark Highway, property owner and Ware. And I just wanted to corroborate and agree with Mike O'Day's statement that there was an attempt by the town to change the planning and zoning regulations for this very instance, and it did fail, and it should not, it failed by a significant majority, and it should not be a backdoor variance approval. Thank you.
Thank you. Thank you, John. Okay, we made it around the horn
No,
once.
no, you have a Doug Elwine's hand is up.
Where? I don't see a hand. Where is it? I don't see him on the screen.
Elwine, ALWINE.
Oh, I'm sorry. I missed him.
Yes, I'm
Oh, here we go. He's not, doesn't have a picture. I'm sorry. Go ahead.
yeah, my laptop died and I had to quickly switch computers, no camera, sorry.
That's okay.
I'm Doug Allwine. I live at 297 Quaker Street. And I have to say that is one heck of an ugly building that looks like it's ready to take over the whole street. And I have to call out, Jack was saying several times that, you know, it's a normal residential garage. It is not. It is probably bigger than my house. This is an enormous building.
Just so I'm straight, you're correcting me, right?
Well, you and
said
everybody
Jack.
else who refers to it as a
I
normal
haven't.
residence.
That I'm aware of, but maybe I did. Sorry.
I think you did, sir.
Okay, that's fine.
You tried to say everybody has a garage.
Oh, I'm sorry. Yeah. Go ahead.
But so anyway, that's about all I have to say, that this is an enormous building. It's not just a normal garage. And it is definitely a blight on the neighborhood. Thank you.
Okay, thank you very much. At this point, I hope have we done everybody that wants to speak under the categories, the 4 categories? I don't see any extra hands,
No,
at least
I
for the
don't see
first
any.
time. Pardon?
I don't see any more hands now.
Thank you. At this point, Gil Shelley, I keep seeing you pop around the screen. Okay, if you wish to rebut anything, expand anything you said before, it's your privilege at this point. We gotta wait for Naomi to do her magic. There we go.
All right, I'd just like to start, all of these numbers that he's coming up with are all based off of Google Earth. No, Meridian never came and asked our permission to come do any measurements or any kind of survey on our property. So I don't know when that happened or how they got their measurements when nobody was here. There was nobody on the property. How'd they get accurate measurements? Second of all, it's not about the appearance of the building. It's about the setbacks. The industrial building, I've heard a million times, and he's gone around town and made it about an industrial building. It's a garage that I use for my own use. It's not anything crazy. It's one single floor. It's what I asked that I could get. So it is on, that's what I wanted, and that's what I asked before I did this.
And you can see that there are several others throughout town on
That are-
Center Street, on
Wait a minute, who's
77,
speaking?
on River Road. I'm sorry, that was me, Shelley.
Oh, I'm sorry.
Sorry.
I thought somebody was speaking. Oh, I'm sorry. I can't keep track of all the
I'll
blocks
let Gil
like
speak.
Hollywood Squares
well-
popping around.
Yeah, that's all right, no problem. She was just referring to that. That's not the biggest garage in town. There's much bigger garages in town that are on residential areas. They're the same style building. I mean, it's not about the material that I used. It's about the setbacks. Like I said, he can keep coming up with all these numbers that, you know, he's providing that there's no proof of any of this. The driveway drainage his driveway is significantly higher than my garage. I don't know how the water would flow uphill. He gets 7 to 10 deliveries from Amazon, UPS, Pernard Waste. They're in and out of there. So if you live in Ware, you have a muddy driveway. It was muddy before, it's going to be muddy after. It's not anything that's going to do with my garage. Second of all, I don't have to ask his permission where my garage is going to be placed on my property. It's not where he wants it. It's where we ask the town where we could put it. We followed all the rules. We did not violate any cease and desist order. We did not do anything against the town. We did everything that we did was with the town's permission. All right. Yeah. All right. The foundation that he is referring to that's already down there is a 50-year-old chicken coop. That's what he's talking about, the slopes. I don't know where he's coming up with all these slopes, all these percentages, all from Google Earth. I think we'd have to have a little more information than what he thinks is on Google Earth. All right. I'm very upset about this. He's spread a lot of lies. He's made a lot of accusations, and he can come up with all the numbers that he wants in his head, but none of it's true.
Gil, let me just say, we don't want to make this a personal discussion.
Okay, I'm sorry.
Yeah, just, keep the references out, okay?
Yeah.
You
All
can challenge his information, but I wouldn't call them lies, okay?
Okay.
Thank you.
Thank you.
You can continue. I just wanted to point out that would be an inappropriate comment.
Yeah, no, okay. Like I said, it's been crazy frustrating. We followed all the rules. We've done everything that we were supposed to do. And we've been chastised by the town, not by the town, but the other people of the town, and they don't even know the full details. So we followed the rules. We did everything we were supposed to do. We were open with all the information, and we just wanted to rebut that some of those accusations that he made are not correct, are incorrect.
Okay. Okay. I guess my question is, you spent a lot of time highlighting other locations, especially out back behind the sewer / the dog kennel sits over the septic, if I understand.
Yep.
And you still have to be 25 feet back before you put the 60-foot or the 40-foot wide, whichever section it is.
Correct.
And what's your opinion on that as far as a cost issue?
Well, I mean, first of all, our garage would have to be, 60 feet from up a hill. We'd have to walk up a hill to get to the garage. Most people want their garage somewhat close to their house so they can park their cars, bring in their groceries. If I had to put it down there, I mean, that's not a practical spot. I mean, then I'd have to have another entrance. I'd have to build another driveway down, which is in the middle of the hill. So, I mean, like I said, we put it there because we'd asked, and that's where we were given permission to put it. So that's why it went there.
Okay, anything else? This is your shot.
Yeah. Anything else, anything you think?
I think the highlight is just the drainage that he's talking about, how our garage runs off into his driveway. But as Gil said, the water would be flowing uphill in order to reach his driveway. And I know the setback is 18 feet according to Meridian. Plus you have that row of trees that are between our property line and the driveway. So it's beyond 18 feet to his driveway.
So if I get it straight, you're talking about the boundary that you have in common?
Yes.
Where the driveway is. So who owns those? So who owns the rock wall?
The rock wall is on the line.
He erected the rock wall.
Yeah.
Okay, that's fine. And whose trees are you speaking about?
They are Travis's trees, but they
Okay.
add 6 more feet between our building and the driveway.
Thank you. Okay, just want to make sure we get it correct. Anything else?
No, I think that's where we're at.
Okay, well, thank you very much.
Thank you.
Approving of butters wish to speak for the second time. If you don't feel you need to speak, that's good too. I don't see any. Naomi, you see anybody?
No, but you had a board member, Malcolm, had his hand up. Do you want?
Oh, Malcolm, where are you? Sorry
Hang
about
on.
that.
Hang on. Malcolm, is your name Malcolm now? Yes.
AKA Malcolm.
Yeah.
I've heard something batted around now, and I heard two different sides of this. Was this built in violation of a cease and desist order? Shelley, Mr. Duquette, you said this is not so, but I have somebody saying it is. I'd like to know, just for a fact, yes or no, what's the case there?
I don't think we have the facts here
Why
tonight.
don't we have the facts?
We have hearsay. Okay,
I know, but I guess I would further my question to say, why don't we have the facts? This is a matter of our code enforcement officer either issuing something or not. We should have the facts.
unfortunately, that person's not here to ask the question. It's an interesting question, but
No, I think it's very key because I've listened to a lot of stuff and I'm not trying to insult anybody on either side, but there's a lot of bloat going on here.
Yeah,
But that I'm keying on because I think it's very important. Was there a cease and desist order? And was it violated? And that,
Malcolm, go ahead. I'm sorry. I didn't mean to
yeah,
interrupt.
go ahead. I think I don't want to bloat anymore.
I agree that it is a very interesting point, and it'd just be interesting to find out about it, but I'm not sure it's relevant to what we're being asked to decide tonight. This is about the variance, which it doesn't matter if the building exists or not today. It's whether or not the variance is something that meets the points of hardship. In our
I
case.
think it is very relevant to the hardship. I've seen a lot of cases where the applicant has created their own hardship and then tried to claim it as a hardship. This seems to be what's going on, and that's why. And I don't know if that's true. That's why I want to know whether this cease and desist order truly exists, and if it was violated. And that is something that should have come from our code enforcement officer, and it has a very strong bearing on this case to me.
well,
And I don't want to argue anymore. That's my point, basically. And I didn't get
I understand your position,
Yeah.
but irrespective of whether it was or was not a cease and desist, upheld, overturned, released, or whatever, at what point, the Duquesnes have a due process to come before the zoning board and ask for variance.
Yep.
So we're here this evening. So I just want to make that point. It may be interesting. If you feel strongly that it's a big issue, you should vote accordingly. But I think it's a question where this thing has got a long beard on it. It's been through the courts. We're here this evening because it's a properly filled out variance, and we're hearing testimony, and the board will hopefully make a decision this evening. So with that, I appreciate everybody's inputs. Not yet, Travis. We kind of skipped over quickly. Are there any approving abutters that wish to speak for the second time? I just want to make sure we get everybody. There is none, okay. Disapproving abutters, Cochran, Travis, go ahead.
Okay, first, a factual question. Gil was asking, how could I possibly have a survey from Meridian if no one stepped foot on his land? So surveyors are allowed to set foot on land even without permission, but in this particular case, I asked Meridian to do reflectorless survey technology. So they worked off of monuments on the street and in my property to get the precise coordinates of the survey that I sent in a couple of times. Is my video coming through okay, by the way?
Yep.
Great. Here's a copy of the cease and desist dated 2 November 2019. And I can read out the timeline again, talking about when the construction was done.
It's an interesting point, but
okay.
Thank you for showing that.
You're welcome.
But does it ever say if it was ever lifted?
It was not lifted, and there is no evidence that it was ever lifted because it wasn't.
So we don't have any information on that either. So
well,
I just want to deal with facts.
Right.
Now,
so as far as facts, I didn't catch
this
the last
is your
name.
second shot. Would you
Right.
like to say anything
Yes.
else?
Excellent. So I had a whole bunch of citizens lined up for last time, but then the attorney's father died, so we had to cancel the meeting. And those people sent me statements. So I'm going to read from Walter Rosen at 290 Quaker Street. I'm new to the town and I'm not looking to make waves, just my 2 cents. I'm looking into where I can build a garage on my property. Due to the setbacks, I can't just put it where I want. Should I just build it and ask for permission later? That's Mr. Walter Rosen at 290 Quaker Street, disapproving of the variance. Howard Kalugian,
disapproving?
Disapproving, that's correct. Howard Kalugian, 217 Colby Road, disapproving. I'm a citizen of Ware living on Colby Road, and I'm against this proposed variance. It's a terrible precedent to violate a zoning code, disregard a court order, and circumvent a town warrant article vote. How many times must elected officials be told no until they get it? Favoritism and cronyism does not make for good government. Disapproving. Third, disapproving, Tara Mann at 51 Worthley Road. In regards to the variance request for 271 Quaker Street, I would ask the town to emphatically and definitively deny the request. This matter has been previously fairly and impartially adjudicated at the expense of taxpayers of Ware and found to be illegal. I implore the town not to waste taxpayer money to pursue a matter that benefits just one taxpayer at the expense of every taxpayer. I also ask the town to consider the appearance of a conflict of interest in granting this variance. To do so would undermine public confidence in our town representatives to conduct themselves with fairness, impartiality, and integrity. Lastly, the granting of said variance would provide one taxpayer relief to the detriment of another. The voters of Ware made their will known in regards to the building accessory structures within setbacks by the vote on warrant Article 4 in the negative during our town voting in March. To grant this petition for a variance would be to directly and blatantly defy the will of the voters, as Article 4 was decisively defeated, thereby demonstrating the people's wish that the structure not be built within the stated setbacks. Granting this variance would substitute the will of a very few for the will of the people. For these reasons, I believe it is in the best interest of the town of Ware to deny the request for a variance.
Okay. Do you have any
And
more?
having said that, that's the entirety of my second round of comments. Thank you.
Would you please send those to Naomi
I will.
so we have it for the record?
Great, will do.
Thank you. You're all set.
I'm
Travis?
complete. Thank you.
Thank you. Any other disapproving of butters wish to speak for the second time, or if you woke up maybe the first time? I don't see any hands waving. I don't know. I see somebody scratching his head, but okay. All right. Public at large wish to speak again for the second time or the first time? I don't see anybody doing anything. Okay. Other boards? I don't see anything there. Okay. All righty. So before I shut down the public meeting, Travis, I just want to ask a simple question. Is there any conditions that you would consider reasonable that we place on this variance should we approve it? You got to let Travis back in again. Okay, Travis.
Great. I believe that there is nothing that can be done with the structure in the situation where it is that would ameliorate either the physical destructive impact on my driveway, nor on the curb appeal and thus the value of my property. I worked through the math earlier, and I'll make sure I send that along in the email. But the amount of damage this does is on the order of $100,000. So no, I can't understand anything that could be done.
Okay, well, thank you. I just wanted to ask the question. Okay, at this point, I'm going to shut down the public hearing. And at this point, the ZBA will consider the 5 points of hardship. Where's Mike? I keep losing people. There we are. Okay. Mike, would you please move condition for acceptance of prong one?
I just, for the board, just a couple of points, if it's all right, I'd like to make. Just a couple of things I think we should probably set the record straight. The ordinance failure that happened in March with the town meeting, that was specifically to change the zoning ordinance to allow this type of setback. It was not to prevent the zoning board from granting variances. The zoning board still retains the privilege of entertaining these types of variances. So that's why we're here tonight. If it had failed and removed that right, we wouldn't be here this evening. I think that's important to point out. And just a couple other points I wanted to talk about. Nowhere in the variance does it talk about the specific specifications for the building. We're just specifically looking at the setbacks in this case. And along with that, prior cases aren't really relevant, in my opinion, for this particular discussion. This is all about this variance request and whether or not the Gills the Duquettes are meeting their 5 points of hardship. So sorry, Jack.
No, that's okay. At this point, will you be willing to make a move to accept the R1?
Absolutely. Yeah, I move to accept Article 1 of the 5 points of hardship.
Before we get a second, I'd like to offer some language for a possible condition. And the condition would be the setback be no closer than, the sideline be no closer than 15 feet. And the setback from the road no less than 30 feet. So that's the condition. We always put that on there so we know what we're voting for. I think based on the concerns I've heard, that at least from a site issue, that plantings be put on the Duquette property side. Evergreen in nature and spaced 6 feet apart, 7 feet apart, 8 feet apart. I mean, pick 8 feet because any tree will probably grow in 5 years and provide a screening. So I'd like to offer that the 15 and 30 be the setbacks no closer than, and also some plantings on the Duquette property. Somewhere is halfway between the boundary and the building. So it's sort of in the middle. Give it plenty of room to grow. Do we have a second?
Second.
Thank you, Bobby. Any discussion on this article, the board? Everybody else set? Yeah, you got everybody turn mark on, please. Just so we get going here. So we get all the members turned on so they can.
Point of procedure, Jack. Are we voting on your wording or are we voting on point 1?
I'm adding that to his, and I'd like
I can add that, yes, it's in the motion if that's all right.
if you could repeat that so we can make clear what the motion is.
Okay, yeah, I just want to make sure that's.
Oh, that's okay. No, that's
Absolutely.
why we're doing it.
Move we accept Article 1 with the conditions of no closer than the building being 15 feet from sidelines, 30 feet from the front boundary, and that there be additional plantings on the Duquette's side. Evergreen plantings on the Duquette's side of the property.
That's the motion. Second again, Bobby Joe. Thank you. Any discussion from the board members being none? Let's see, go around the room here. Mark?
Aye.
Aye. Bobby Joe?
Aye.
Malcolm?
No.
And Mike?
Aye.
And I'm aye. So that's 4 yes, 1 no, and no abstentions. Okay, that passes. 2, please.
Move to accept Article 2.
Thank you. Second.
Second.
Thank you. Any discussion from the board? All those in favor? Mark?
Aye.
Bobby Joe?
Aye.
Malcolm?
No.
And Mike?
Aye.
4/1 0. Okay. 2. 3. I'm sorry. 3.
Move to accept Article 3.
Thank you, Mike.
Second.
Bobby Joe, thank you. And any discussion from the board? Being none, all those in favor? Mark?
Aye.
Bobby Joe?
Aye.
Malcolm?
No.
And Mike?
Aye.
And myself is yes, so it's a 4-1-0. Okay, number 4.
Move to accept Article 4.
Thank you. And second?
Second.
Thank you. Discussion on the board? Being none. All those in favor, let's see, Mark?
Aye.
That's 1. Okay, Bobby Joe?
Aye.
Malcolm?
No.
And Mike?
Aye.
And myself, aye. So that's a 4-1 again. And 5 is an entirety.
Move to accept Article 5 in its entirety.
Thank you.
Second.
Second, thank you. Discussion, being none. All those in favor, Mark,
Aye.
Bobby Joe,
Aye.
Malcolm,
No,
and Mike.
No,
You're a no as well?
I am.
Okay, and I'm a yes. So that's 3-2-0. Based on the results, it passed. So we'll move on to the next case. And that case is number 06-2021. By the way, just so everybody knows, I should have said this earlier probably. Formal minutes should be done within 144 hours, 6 days. And you should be able to get a written judgment out of the what do you call it? Documentation on the decision. I think it's within 48 hours, Naomi, whatever it is. So just want to let you know that. And if anybody has any issues, how we conduct this meeting, feel free to let the select board know, because they sit in judgment of us. Okay. Next pile. Okay, this is very good. This is case 06-2021. This is Jeff and Gina Stevens, 1480 832 North, is that Kale Del Prado or something like that. Fountain Hills, Arizona, 85268. Property location, the owner's the same. Property location is 34 Dudley Brook Road, Ware, New Hampshire. Tax map 107 and lot lot is 3. There's a description of 20 foot on Dudley Brook Road, frontage, front of a lot of 402 feet, 402.72 feet, sidelines 718.59 and 825.25. The rear line is 405.2. Residential zone, we are proposing an attached dwelling unit, an apartment over the garage for our own use. And this was continued last time because we really didn't know the status, at least we couldn't figure it out in time of the meeting. So it appears they met all the conditions according to Naomi, that if they get this ADU approved, then they will, the town of Ware will grant the building permit. That's the understanding we have. The concern was, has the driveway permit and everybody involved happy? And apparently it is. So with that, we'll go ahead. There is a compliance checked off. There is a sketch signature, both by William and Gina. There is the 7 points, which, by the way, on a special exception, if you meet the conditions laid out, you get it by right. It just wants people to, the board, take a little extra look and see if it's complying. It's very difficult to write all the specifications for an ADU, so it provides the guidance for us in Article 19, and we look at that. The butters, tax map, warranty deed, Exhibit A, long discussion, driveway permit enclosed, Ware Planning Board minutes from July 12, 2018. There is a tax card, a Scottsburg River Local Advisory Committee meeting and minutes, permit, I guess. And there is a design here, which basically is a B size, which means 2 A's. And it's basically only the ADU in the breezeway. I did go up and look at the complete drawings, and as far as where the door appears on the ADU, it's not on the same surface, same side as the main entrance to the house. So from that perspective, it's compliant. And that's it. So at this point, motion to accept, motion to accept the application for 06-2021.
Move to accept case 06-2021.
Thank you. Second, please. Thank you. Any discussion? Being none, all those in favor? Mark? I think we need to have you on the record. We need to turn on Mark and Malcolm. Thank you. Mark?
Aye.
Bobby Joe?
Aye.
Malcolm?
Aye.
And Mike?
Aye.
And 5 me, 500. Okay. And we only require to take a simple vote at the end. But Mike, did you have time enough to get out through the list? The applicant says they're complying with the 750 square feet for the ADU. And I know that as the design presented at the town, the door is in the right spot. So I think there's issue of parking and all that. Article 19.
Yep. You just want me to run through the
Yeah, if you would, please.
the points? Sure. An accessory dwelling unit shall be clearly incidental to the primary use of the property for the single dwelling. As such, the accessory dwelling living space shall not exceed 750 square feet, which we've covered. Will not contain more than 2 bedrooms with a maximum occupancy per bedroom, not more than 2 persons per bedroom. We can see on the plan that you have indicated just 1 bedroom, and I'm assuming the planned occupancy is less than 2 people for that. Should we take the applicants off mute as well, just while we're running through these?
Sure, if you wanted to get a confirmation.
Hello?
We can hear you. And just to confirm, you're not planning more than two
No,
persons per bedroom.
It's a one bedroom apartment that we have up there with, 1 full-size bed in it.
Understood. Okay.
Yeah.
19.1.10.2, an accessory dwelling unit shall either be constructed within or attached to the single dwelling, and it appears from the plan that it is. At least one interior. I'm sorry, was there something? Oh, and at least one interior connecting door or other access for persons to pass between, which you've indicated through this breezeway back to the regular house. Septic system design capacity shall be approved by the New Hampshire Department of Environmental Services. This is a new building, if I remember correctly, so it's considered in part of the complete building plan. No new entrance or exit to the accessory dwelling unit shall be constructed facing the front of the single family dwelling, and I think Jack covered that. We've confirmed that. 2 parking spaces shall be provided for the accessory dwelling unit, and no new curb cut from the street will be constructed. And I believe we talked about that, or actually, can you guys speak to that for a moment?
So we have 700 feet of driveway along which there can be extra parking, but the ADU is above the 3-car garage space in front of a, fire truck circle that's 68 feet?
58 feet in
58
diameter.
feet in diameter. So as you're leaving that circle, there's space on either side of the driveway for extra parking.
Very good, thank you. Exterior construction materials shall be uniform with the single dwelling. You're building it all at once, so that would make sense.
All the same style. Yes.
Very good. And either the accessory dwelling unit or the principal dwelling unit shall be the principal residence and legal domicile of the owner of the property. I'm assuming you guys are in Arizona right now. I'm assuming you're planning on becoming where residents?
Yes, yes,
We're originally New Englanders.
yeah, we're looking forward to getting back northeast again.
Very good. Welcome back.
Thank you.
Zach, I think that covers everything.
Thank you. At this point, could I have the applicant read the question and your answer to the question for each one of the seven points there?
Okay. The specific site is an appropriate location for such a use or uses as, in terms of overall community development. 7-acre site with room for a house with an attached garage in the middle of the large wooded lot, hidden from the road and neighbors with a 700-foot driveway.
Okay, 2.
The proposed use will not adversely affect the neighborhood and shall produce no significant reduction in real estate values in the neighboring area. None of the neighbors will see or can see the garage from their property. The terrain and trees screen everything.
Okay, 3.
The proposed use will not be a nuisance or a serious hazard to vehicular traffic or pedestrians. The proposed garage apartment is 500 feet from the street.
Okay, next, please.
The proposed use will not cause an undue burden on the town through the provision of basic town services. None.
Okay.
Maybe we don't know how to answer that, but number 5, adequate off-street parking will be provided if determined necessary by the Zoning Board of Adjustment. We have 4,800 square feet of parking along the driveway.
That seems to be 20. 6, please.
A buffer may be required to screen neighboring uses from the proposed use. Buffers may be fence screens, dense planting of suitable trees and shrubbery, or naturally occurring shrubs and trees.
Okay.
It's already buffered because we're building in the middle of a wooded site.
Okay. It's 7. This goes without saying.
The zoning, Board of Adjustment is granting special exception, may include such restrictions or conditions to ensure compliance with this section.
Very good.
We didn't put anything there.
We're over here now, okay. You want to say anything else before we get to the butters and such?
Do we need to say anything else?
I don't think so.
Okay. That's fine. I just give you an opportunity. Approving of butters who wish to speak to this. I don't see anybody, and can we tell if Laurie's still on, or Jordan, Eric, Brian, and iPad 5? I can't see the video to tell.
Well, they're able to raise a hand. You would see if they.
Yeah,
I can't see. They're blanked out.
Yeah.
I don't see any of the names of the abutters that are on, that we know.
Okay. Okay. I want to make a good faith effort.
Probably worth mentioning, if anyone is off camera, there's a reaction button at the bottom. You can raise your hand as well.
Okay. Any disapproving butters who wish to speak? Again, I don't see anything. I'm hearing something.
Oh, that was my phone.
Oh, sorry.
Got a text or something.
That didn't count. Are you seeing any reaction buttons there, Naomi, from anybody?
I don't see anything, no.
Okay. Public at large? Here we go again.
I'll
Public
turn
at
my phone
large?
off.
Do you see any reaction buttons there, Naomi?
Nope.
And other boards? Okay. There's no rebuttal needed, but if you want to say something else, is your last chance.
Well,
Yeah.
we're trying to build an attractive structure. The garage is really just for our own use. It's going to have my office in it. I draw, and
just a guest room for our kids when they come to see us.
We have 5 children.
So, yeah.
It's just a family home, really.
When we designed the home, we just designed space up there, but then as we talked about getting a building permit, it was pointed out to us that it actually satisfies the need, the description of an ADU. So that's
Okay.
why we're here.
That's fine. Go again. Approving of butters wish to speak. Disapproving of butters wish to speak. Public at large, other boards. You see anybody's hands waving, Naomi? Well, we see something on the iPad happening. iPad 5. Would you please turn Mr. iPad 5 on? You're not speaking yet. He's talking.
I asked to unmute. He's not unmuted.
There, how's that? Can you
There we
hear me
go.
now?
Much better. Thank you.
Hi, I'm Jerry Mirando. I'm using my wife's iPad. I'm not an iPad person, so
Okay, but you're not number 5 anyway, so.
I am iPad 5.
Oh, okay. So you
Yeah,
must have 4
so
others.
I'm the abutting neighbor to the south,
What is your property address?
214 Abijah Bridge Road.
214. Okay, you're down the road. Okay.
Yep, but I abut the south side of their
Okay.
property there.
Are you speaking as an approving of butter, disapproving of brother?
Yes, approving.
Okay, thank you.
Took me too long to
Okay.
find out how to unmute and work the pad.
Well, it
So
wasn't
I
your
agree
problem.
I agree with everything they said. There's plenty of, foliage and everything like that. So you asked for, approval or disapproval. I'm approving as well. I have no problem with what's going on there.
Thank you very much.
And I welcome them as neighbors whenever they get over there.
Thank you. Any other approving of butter wish to speak? Disapproving of butter? Public at large? Other boards? You see any activity, Naomi?
Nope.
Thank you. Okay, at this point, I'm going to close the public meeting, and we'll just take a simple vote in the positive. Mike?
Move to accept the special exception for case 06/2021.
I have a second. Thank you. Discussion on it? Being none, all those in favor, Mark?
Aye.
Bobby Joe?
Aye.
Malcolm?
I just got unmuted. Aye.
Saved by the bell. And Mike?
Aye.
So, and I'm aye, so that's a 5-0-0. We welcome you paying taxes pretty quick. Thank you. Okay. Case 08. This is paintball. Okay. This is 158. This is case 08-2021, 158 Daring Center Road, map 411, lot 21, 28.5 acres, rural agricultural zone. Owner is the same as the applicant. Okay. There's 5 points of hardship. We kind of went through this before. It's a continued case. And we got a compliant list, butters, tax map. Meridian's location. Talking about signs, pictures of signs, size of signs, sign, piece of the sign ordinance. Okay, if I remember correctly, is there somebody here from Meridian who wishes to speak? I don't see anybody from Meridian.
You don't have anybody from Meridian.
Oh, Tom. Is Tom sleeping?
No, that's not Tom.
Oh,
Eric is the owner of one of the owners of
Okay.
You don't have anybody from Meridian, just Eric is on.
Eric, you there?
Yes, I am, Jack. Can you hear me okay?
Yes. Were you here the last meeting?
Yes, sir.
Did you, because you're asking for variance, but we don't know how much for.
So we did have Tom locate the height of the sign, and the height is, I just want to get it exactly here. Bear with me 1 second.
So Eric, while you're looking for that, Jack, I just want to refresh your memory. You threw me under the bus at the last meeting.
I think I did it 3 or 4 times.
Yeah, in the minutes, it says you explained that I was the one to decide about the height,
No.
about the
Didn't you?
size.
Did I mean that? No, you don't decide.
No, it says the zoning board
well-
does not make the determination.
Well, let me back up. Typically, somebody hands a letter saying you're not compliant. To my knowledge, that never happened. Meaning the code enforcement officer should write a letter for a violation. And that's the basis for people coming in who wish to correct that through a variance or fix it physically. So I think I was referring to that.
He's not in violation. You allow him 16 square feet for a sign, he's 9.25.
No, we're talking the height.
Right, but you asked me to decide on the 9.25 or the 16 feet.
Okay.
So he is compliant with the 9.25. That
Okay,
business the business has been around since 1988. That
Yeah.
business, so.
Right, I understand that. So what we're only talking about this evening for variance is the height.
Yes.
So we want to say something to the tune of no taller than. And do we know what that number is?
Did you find it, Eric?
It's 12.5 from center line.
Center line of the road.
Yep.
So you're asking for 12.5 feet measured from the center line, height measured from the center line of Route 114. Okay. And compliant is 6 feet. Is that correct? I believe it is.
I believe so, 6 feet.
That's correct. 341012 says the height of such sign shall not exceed 6 feet from the center line elevation of the road to the top of the sign.
I mean, I really don't understand the merit of the 6 feet. I mean, you can get a tall snowbank in the wintertime, and I don't think you'd be able to see a 6-foot sign. I don't know. I mean,
In fact, even with our current sign, the snowbanks are typically at the bottom of it currently in the winter. Our old sign would get buried completely.
I mean, from the street.
Yeah.
Okay. So, take a look at your variance. And if you want to go through your 5 point, wait a minute. Did we already accept? So we've already accepted this application last time, I correct? So we basically are just going to proceed with the, any questions from the board before I ask the applicant to proceed? Being none, okay. Would you read the bolded variance language and put your and tell us your answer as well, please?
Yep. So the variance will not be contrary to public interest. The variance requested will not be in contrary to public interest because this existing sign height provides a safer means of site access, as a lower sign would be obstructed with the roadway and site itself upon approach. The public benefit from clear identification and directions into the site.
Two, please.
Please provide how the spirit of the ordinance is observed. The purpose of the Town of Ware sign ordinance is to support the general provisions of the Ware Master Plan, which seeks to enhance traffic safety and preserve the visual rural character of Ware in accordance with the Ware Master Plan. The spirit of the ordinance is observed through providing a safer means to access site while maintaining the essential character of the neighborhood, which AG has been a part of for 30 years.
Mhm. Three, please.
Please describe how suitable justice is done. Suitable justice will be done because there is no public gain from denying AG paintball signage that is required due to obstruction associated with the roadway and the site itself for safe site access.
Okay, four.
Please describe how the values of surrounding properties are not diminished. The value of surrounding properties will not be diminished as AG Paintball has remained in the same location for years. The existing sign provides a visual aesthetic that fits the property, and the property itself has a landscape buffer that abuts parcels, so the sign is not will not be visible.
Okay. I. Did you
You
do
want
five?
Five,
Did you do
no?
5A? Yes.
I have not done 5A. So
I'm sorry, go ahead.
literal enforcement of the provisions of the ordinance would result in unnecessary hardship. The entrance of the property is located on a sharp turn in the road with a significant elevation change. As typical, the exiting sign is located at the entrance to the property. As stated earlier, a lower sign would be obstructed associated with the roadway and site itself upon approach. A higher sign allows for safer means to access the site, allowing customers to have proper stopping time prior to entering the site. We want our customers and general traffic to be able to enter and exit and pass the entrance safely.
Okay, I, please.
If the sign is shortened to the 6-foot requirement height, the sign will no longer be visible from this one direction of the road.
Yeah, you should read the question.
Oh, I'm sorry. Owing to the special conditions identified above, please indicate how no fair or suitable relationship exists between the general public purpose of the ordinance and the specific application of the provision to the property.
Okay, I, please.
Owing to the special conditions identified above, please indicate how the purpose or the proposed use is a reasonable one. By allowing the sign to be slightly higher than required, it will allow for proper timing for customers to enter the site without altering the barn's antique loading dock and to maintain the existing rural look of the property.
Okay. And you didn't do B, did you?
We did not do B.
Okay, that's good. Okay. Any question from the board of the applicant? Being none, I'm looking at a lot of head shaking. Approving of butters wish to speak? I don't know who is on a butter.
I don't think you have anybody on.
Okay, just approving of butters wish to speak? Public at large? Other boards? I'll give you another shot if you want to say something, Eric.
No, I think I'm good.
Okay, thank you. And then again, butters, approving, disapproving, public at large, other boards wish to speak? Being none, at this point, I'm going to ask that we have the motion to accept prong one.
Do we want to put a height restriction? No taller than
Yeah,
on it?
we said it was 12 feet, right?
12.5, I believe is.
12.5. So by their own calculus, say no larger than 12.5.
Move to accept.
Naomi, can you unmute Malcolm? He's trying to say.
He's trying. I see him. I was looking at you, Malcolm.
I've muted myself. Apparently, I
You
can't
might
come
have
back
done
from that.
No, he can't.
Dark road. We all set?
Malcolm, you have something you want to say?
Nope. I just
Oh, okay.
want to make sure
I thought you had a comment. All right.
Move to
Okay.
accept Article 1 with the stipulation that the sign be no taller than 12.5 feet from the 114 center line.
Second.
Thank you.
It's one,
Discussion?
it's 149, not 114.
149, excuse me.
Oh.
Right.
Thank you. Yeah, that would be heck of a survey there.
Okay, that's been a long ways from the center line. Okay, so we have a second discussion from the board. And being none, all those in favor, Mark,
Aye.
Bobby Joe,
Aye.
Malcolm,
Aye.
and Mike.
Aye.
And myself, Jack, that's I, SOS 5, 0, 0. Okay, 2, please.
Move to accept Article 2.
Second.
Thank you. Discussion, being none, all those in favor, Mark,
Aye.
Bobby Joe,
Aye.
Malcolm,
Aye.
Mike,
Aye.
Jack, 5/0/0. 3, please.
Move to accept Article 3.
Second,
Second.
discussion, being none. All those in favor, Mark,
Aye.
Bobby Joe,
Aye.
Malcolm,
Aye.
Mike,
Aye.
and Jack, 5, and I'm I, /0/0. And 4, please.
Move to accept Article 4.
Thank you. Second, thank you. Discussion, being none. All those in favor, Mark,
Aye.
Bobby Joe,
Aye.
Malcolm,
Aye.
Mike,
Aye.
and Jack, aye, so that's 5/0/0. And 5 is an entirety.
Move to accept Article 5 in its entirety.
Thank you, Mike.
Second.
Thank you, Bobby Joe. Discussion from the board, being none. Mark,
Aye.
Bobby Joe,
Aye.
Malcolm,
Aye.
Mike,
Aye.
and Jack, aye, 5/0/0. Okay, you got your variance. Good evening, Eric.
Thank you very much.
Okay, we're on the last one. Okay, we actually we ended up with 2 variances. And let's see here, make sure we got one here. I gotta get my stuff straight here. I got too many pieces of paper. Trying to figure out, I got 2 copies, so I got Article 17 on this one. Article 17, so I got 2 packages. One's thicker. Oh, it's because it's got an attachment on the back. Is there any difference between these 2?
You should have 1821 and 1711 altogether.
No, I got 2 17s.
I do. That's the same for me also.
Maybe this 17 that came in with the 18 was a copy
That could
of
have
what
been.
we had that has the attachment
That could
of
have
the
been.
map. So I'm going to go with the one with the attachment of the map, because I think it's a copy of the 17 that came in the latest mailing.
It could have been because he applied a while ago.
Right, makes sense. Okay. So typically, unfortunately, we get a little out of step here where 2 articles, we usually put them on the same because most of the same stuff is the same. Unfortunately, we have 2 applications, so we're gonna have to go through this twice.
Well, that's because I asked him to.
Yeah, no, I'm not saying it's your
Okay.
fault. I'm just saying it's a fact of where we are.
Okay.
And
Oh.
unfortunately, you guys got shipped to the planning board last time when in fact, the planning board figured out you weren't supposed to be there after all. So we're back here again. And, but was missing for the continuance was you didn't have a 1711.
Okay.
So it's done here, okay? So with that said, let's take 1711 first. Everybody, you guys okay with that? Planning board, I mean the zoning board? Okay, let's see here. Have we got everybody here? I see Jordan and Brenda.
Brianna,
Sorry. I'm not very good at those things.
Good evening, everyone.
Who else?
you have a couple more on.
Oh, I see Laurie here still. Eric,
Tom,
he's still
Tom
hanging on.
and there's Attorney Eggleton,
I don't see him here.
Jeremy Eggleton.
Oh, I'm sorry. Now I see you.
Yes, and
And
then
who
there's
you
Tom.
represent, Jerry?
I have him muted, but
Oh,
I believe it's Mr. Page.
and so just for is that the person that owns the property or the person on 21?
I'll let him answer. I just
Yeah, let
unmuted.
him come up.
Can you hear me okay?
There
I
he
can
is.
now, thank you.
Hi, everybody. Thank you.
You represent 21,
I represent Mr. Page, the abutting property owner.
which is 21?
Yes.
What, 21?
Yeah.
Okay, thank you. I just want to make sure we had everybody here before I go through this whole thing and figure out we don't have the right people. Okay, let's see. Okay, for 1711, which is case 10, 2021. And unfortunately, I don't have a cover sheet for 18. But we can use 17's cover sheet for that.
So Jack, what I said to the couple was, you didn't need two full packages of the same thing. You just needed the regular application plus the, whatever the 5 points for 1821 and 1711. That's why
And
you
they
didn't
did
get
that.
double the paper.
Right, they did that, and
They did
I'm
that.
okay with that.
Okay.
We're just gonna have to treat this as sort of the sibling to 1711. Okay, let me just go through the application for 1711. There's a proposed use. There is property, this is case 10-2021. And for the sake of this evening, we'll call it A, if that helps. As for 1711, Park Clough Road is the property address map. 2019, was it 409, lot 20. I'm sorry, it looks like a typo. And acres 24.4, rural conservation. Applicant's name is Jordan J. Estrada. And the property owner is Lewis Page, which you represent.
Yes.
Jeremy? Thank you. Okay. Let's see here. We have a proposed use. We have a page from Mr. Page giving counsel. And then we have the article and 5 points of hardship for 1711. And we have the clients. We have the deed. We have a tax map. Tax map, and we have a tax property card. Looks like a location of the lot. Butters, tax map. 1711 out of the excerpt. Set 37 does not exist at this point. There is a deed here. Looks like it's backwards, so it's a warranty deed. There's also a quitclaim deed. There's also driveway permit That's it was signed off. Is this the current one? What's the date on this? Yep. Then we have a map. This is a plat for Peter DeJaga property, Ware, New Hampshire. Looking for a date, and this is January 19th. Looks like January 19th, 1978. So this must have been the original one. And it looks like it's been changed around since then. Make sure I get this right. No, I guess we're okay. That's 21. This is 20. So am I correct? The Peter DeJager is now lot 20 by any other name for your client?
Yes, this is lot 20.
Okay, just want to make sure.
Yes, is the one we're applying for.
Good, okay. Because it is an older,
Right.
hate to do this to you, but we're
No
gonna have to
problem.
do this twice. So if I got it correctly, you're looking to get a variance for a building permit.
Yes.
So you can build on lot 20 because it's on a private road, and 1711 says no building on a private road, correct?
Exactly.
Okay. So there's also something I need to say as well, and I can't find it right this minute. Hang on. We have a letter, which I won't read, but I will say what it is. It was sent, Oren Reno is a Concord-based law firm. And it looks like this was written by Jeremy D. Eggleton, I believe it is, Esquire. And there is 1, 2, 3, 4 pages to his letter and one exhibit, which is decision of notice. And this was from 02. And I might start out by saying that there was originally a variance in 02. And the way my interpretation, confirmed by town council, is that in 2010, there's been a substantive change to the 5 points of hardship, which basically gives people that were denied a variance. It's basically one strike, you're out, you can't come back unless it's substantially different. Well, what's substantially different here is in 2010, the 5 points of hardship got jiggled around and wicked around. So the criteria for a hardship is different than what it was in 2002. So to Oren Reno, Esquire, Eggleton, he was saying you already had one shot. You've been up to bat, one strike, you're out. But according to the town attorney, you got another life, you got another shot. So we will hear it. And he speaks about it. He's got all kinds of stuff that he talks about the variance. And is there anybody here this evening to speak to this? You want to speak to that, Jeremy? Let's hang on for a second. Because you do have it for your 5 points of hardship. Why don't we just wait till we get there? Okay. Okay. Just want to make sure everybody's.
So Jack, the Mr. Eggleton represents the abutter.
I understand that.
Okay.
I do now.
Okay. And he's on, so.
He's on. Okay, we'll let him speak to this when he gets to his abutter's rebuttal, if you wish.
Okay.
I just want to make sure I didn't forget this memo. It was kind of important for his position. So again, that's the position that the town attorney took, and we're sticking with it. So with that said, motion to accept case 10, 2021A
Move to accept case 2021A.
Thank you. Do I have a second?
Second.
Second.
Thank you. And any discussion on what we're doing here tonight? Just so I get it correct. Okay. Did I lose somebody? What happened to Malcolm?
I'm still here.
Oh, you.
I just lost my video for a minute. I think it's fine.
Okay. I figure we lost you. I just want to make sure how many people we got going tonight. So you are definitely here, Malcolm.
Yeah, I'm here.
Because
Thanks.
if we didn't have 5 people, you would have the right to ask for a continuance, so you can get 5 people to say 3 times yes, instead of 4 people or 3 people. So I just want to make sure. Okay. All righty. So motion. So discussion being none. All those in favor? Mark.
Aye.
Bobby Joe.
Aye.
Mike.
Aye.
Malcolm down the bottom now.
Aye.
Thank you. And Jack. Aye. That's 500. Okay. At this point, any questions of the board of the applicant before we get started? Okay. Jordan, Brianna, if you guys, whoever wants to do the talkings, please read the bolded question. And
Sure.
your answers, please.
Absolutely. And thank you all. So the first point is the variance will not be contrary to the public interest. So our point under this heading is that it is a large lot at the end of a private drive. Our plan is to keep most of it in current use and only build in a small building envelope. Our plan is to build a modest single-family home in keeping
Would you
with
read
the
what you got there,
characteristics.
please? Would you
Sorry?
read it?
Oh, do I read the application verbatim?
Yes, please.
Okay.
This way it's in the record.
Okay, perfect. Let's see, where am I? The variance will not be contrary to the public interest. So the primary purpose of current use lands in the rural conservation zone is to conserve and manage important habitats for the benefit of regionally or internationally significant fish and wildlife species. With our proposal, we would keep the majority of land in current use. Living on site would enable us to cultivate and improve the character of the conserved land by practicing on-site stewardship and good forestry practices. The subject lot is 24.4 acres, and we would only utilize approximately 2 to 4 acres as the building lot and keep the remaining acreage in current use to maintain the general purpose of the ordinance and the essential characteristics of the area. The proposal would not threaten the public health, safety, or welfare, or otherwise injure the public's rights, as much of the lot would remain as it is today, and granting us the ability to live on site would ensure that the property was well cared for and free of hazards to visitors and wildlife. The private drive in question is wide and well maintained with an excellent grade. I believe I attached some pictures and diagrams of that to my application, and it easily allows multiple vehicles to access it.
I just want to go on record that I went out there when there was still frost in the ground, thawing cycles. And I just got to say, it's better than some class 5 town maintained gravel roads we have in town. It's very wide. The gravel surface appears to be well drained. I'm not suggesting that ice don't form when it's snowing out, but compared to other roads, this is, from what I understood looking at it, was pretty substantial. So next, are you done with that one? Next one.
Okay, please describe how the spirit of the ordinance is observed. So as I said, our goal is to build a modest, discrete, single-family home, ensuring minimal impact on the surrounding nature and neighborhood. The proposed use will not conflict with the general purpose of the ordinance and will not alter the essential characteristics of the neighborhood, nor threaten the public health, safety, or welfare, or otherwise injure the public rights. Much of the lot will remain as it is today, with nearly the entirety remaining in current use.
Okay. 3, please.
Okay. Please describe how substantial justice is done. So while inherently rigid, there are mechanisms in zoning to allow for flexibility. We are asking for flexibility with this variance application, where the benefit of granting such a request is not outweighed by, will not be outweighed by the neighbors or general public. Granting this variance will provide benefits to the general public, including that if the variance is granted, the road maintenance will be shared with the new occupants of the dwelling, us, thereby benefiting the other residents and visitors to abutting lots. This is, of course,
I just want to make a point about
go ahead.
Your point. It's nice in spirit, but the town of Ware considers any road maintenance agreements to be a civil matter between the parties, and the town of Ware does not want to get involved in maintaining any roads. By law,
Absolutely.
you can't do it. Okay.
And what I'm really getting at is RSA 23181, which was passed in 2019 and would basically say, as people who live on a private drive, we would have a responsibility to contribute to the maintenance of that road.
Well, that's what the state law says. That's what you got to do.
That's what we're going to do. Yes.
Very good.
And lastly, the concept of substantial justice raises issues of fairness for the community and neighbors, and are peculiar to this property, whereas other similar lots in this private drive have had the benefit of receiving building permits. Basically, we're simply asking for the same use that all the other lots on this private drive are currently enjoying.
And to my knowledge, 21 as an active dwelling.
Yes.
18 has access almost to Bark Clough driveway and also access to that particular, the same one 21 and 20 uses, and 19. 19, to my knowledge, there was some rumor that there is some kind of a trailer or a building up there.
Yeah, 19, it has a mobile home and then it has a seasonal cabin. It looks like they put a little cabin by the lake, but it also does have a mobile home on it as well. Unclear if anybody lives there, but that's...
It's not a full-time year-round dwelling. So there's really only 2 existing and 2 lots to go. Yours is 1 and the other one is 19.
Okay.
All right.
Okay. 4, please describe how the values of surrounding properties are not diminished. So the proposed use would not diminish surrounding property values. If the variance is granted, the proposed lot would have a modest single-family dwelling of approximately 2,000 square feet, and this proposal would result in an increase in property value and tax base created by such improvements. The dwelling would be aesthetically pleasing and would fit with the existing homes. The dwelling would also be a significant distance from either of the existing homes on this private drive, as the building envelope for 185 Bark Clough / map 49 lot 20 would be mostly concealed from the other residences due to the topography and the distance between building envelopes.
Okay. 5, please. A.
5A, literal enforcement of the provision of this ordinance would result in unnecessary hardship. The fact that the ordinance in place would restrict building dwelling on the subject lot, whereas others on the same private drive have been afforded the ability to reside and enjoy full use of their property without zoning restrictions, is an undue hardship as the property does not have any substantial special conditions. Additionally, RSA 231-81 requires all owners enjoying a common benefit from the private road to contribute equitably to the care and maintenance of the private drive. Since the owner of 185 Bark Clough is not permitted to live there, the owner experiences significant hardship in fulfilling their communal obligations. If permitted a variance to build on 185 Bark Clough, we would be able to fulfill the owner obligation to contribute to the care and maintenance of the private drive while also enjoying the same benefits of land ownership that others on this drive are currently experiencing.
If permitted. Right. I, please.
Owing to the special conditions identified above, please indicate how no fair and substantial relationship exists between the general public purposes of this ordinance and the specific application of that provision to the property. So basically, as this property is on a private drive, it is currently being excluded from being eligible for a building permit.
Correct. Okay. I, please.
Okay. The request to construct a modest single-family home on a 24-acre lot with good access via a private drive is reasonable. It would be unjust to deny the existing owner and prospective owners the opportunity to ever utilize their land or to have such restrictions placed on them when others have been afforded the opportunity to perform construction, sales of property, and such for similar properties as we are requesting for the subject lot.
B, please.
5B, please describe the special conditions of the property that distinguish it from other properties in the area. Basically, other properties on this private drive have obtained building permits, while no permit is available for the lot that we're looking at.
Okay, and the rest of it down below, owing to the special condition.
Yes. Requiring the owner of 185 Bark Clough to convert the private drive into a Class 5 road would make construction prohibitive to the average middle-class New Hampshire wage earner, and such a requirement would significantly drive up the already high costs of new home construction. Additionally, requiring that the private drive be converted to a Class 5 road would significantly burden the abutting neighbors, as their address would no longer be Bart Clough, and they would all have to incur the substantial aggravation and work to change and update their addresses in all the many places where such info is recorded. Changing the road to a Class 5 would also raise taxes for the neighboring lots because the road would then be town maintained. It would decrease the peaceful pastoral character of the neighboring lots and result in increased noise, inconvenience, and disruption during road construction. Such a requirement would invariably create significant tension and resentment between the current property owners and the new property owner, ourselves, required to convert the road, and significantly decrease the possibility of community and harmony. Without a variance, the subject lot cannot be put to reasonable use. The hardship is due to circumstances unique to the property location where other buildings have been permitted on this private drive. The variance will not alter the essential character of the area, and it is a minimum necessity. Hardship is not self-created. The current owner or previous owners did not create the need for the use of variance. When it was initially subdivided in 1977, it seems clear that all the lots were supposed to have the same access and use. And it is not reasonable for the current owner to use the property as restricted and eliminate undue hardship under the strict conformance with the ordinance.
Okay, I just want to point out, because it's a private road, some services won't go on the road. Post office, school bus, some of you people, delivery people. So that's all on the property owner, on the
Absolutely.
potential property.
Both my wife and I grew up on dirt roads. We're very familiar with that life, and that's basically the life we're looking for.
Well, we have Class 5 dirt roads in the town of Ware that have all the services.
Yeah.
And then we have private and Class 6 roads that do not. Okay, I think we made it through. At this point, there's Eric is still on and Laurie's still on. I know they're not abutters. So why don't we try this, see how we do. Approving abutters wish to speak to this application? Okay, well, Tom? Tom's going to start talking, but we ought to let him turn him on first. Okay, Tom.
I'm not for approval.
This is for approving abutters, and then I will ask for disapproving abutters. So you can decide which one you want to be.
I am in the middle of the road on it. I don't have any problem with the lot being built on, my father selling it, or
Excuse me.
somebody building on it.
Your name, please, so we get everything straight.
Thomas Page, lot
Thank you,
20.
Tom. And it's lot 21?
Lot 21, yes.
Thank you. Okay.
Address
sorry about that.
187.
Okay.
My whole thing on this lot being developed is that I'm the sole person for mostly 27 years that built this road. Nobody helped me. It was barely wide enough for a driveway. You couldn't plow snow. I widened it. I paid for all this, what's done. The first 200 feet since 2006, I've gotten help with the lot 18, which also has right away up to the circle. It's also, so the first 200 feet, the road is pretty good. It's actually where you were parked when you came. You were at the first 200 feet, but you didn't walk down the road and see.
I walked all the way down to 21, almost to your house. I looked at your house, and then we went and looked at 20, and then we looked at 19, and we met you and your neighbor at 18 when I was leaving. So I already made all the trip by that time.
Oh, I didn't realize you had walked the whole thing.
Oh, yes, yes. Matter of fact, I saw your Jeep with four-wheel drive, whatever it is, a Ranger, and it's four-wheel chains, and a note to drop all packages here. So, yes, I did make the whole turn. I walked the woods, and I wanted to see where the boundaries were, and we managed to find them. So, yeah, I did. So,
that's good. I didn't realize you had. Well,
yeah, I made the whole trip, and you were catching us. I think what happened, the dog started barking on lot 18, and so the daughter came out. The next thing you know, the father comes out, and I'm talking to the father And then you show up wondering what all the noise is about. And you came out there at the end of it, and we did speak for maybe 5 or 10 minutes.
Yeah. All right. So my whole issue with that is the first 200 feet is fair as far as gravel roads, but from the next 414 feet to where the circle's supposed to be for the emergency vehicles isn't so good. The path is only 8 to 9 feet wide of gravel for one-way travel. So if you, when a car is coming down, if you push off to the left, the only side you can go, you're gonna make ruts and ruin the edge of the gravel that's existing. So my whole thing is, to build on it, this road needs to be upgraded to two-way travel. I'm not saying a full class 5 road.
We got it.
And even if it was brought up to a class 5 road, which Eric said in his last statement on the points of hardship, the town wouldn't be taking over the road even if it was upgraded to a class 5 road. It would still be a
class
private road.
5. Okay, just so we're all clear. You can petition the select board to take over a upgraded road to class 5 status. And that's usually 22 feet wide, so much base, 3 inches of asphalt, and slopes and all this kind of stuff. It's up to them to decide to accept it. Okay.
Yes.
So there's a process.
My understanding to that is all 4 lot owners would have to write off for the
Well,
town
that
to
becomes a
accept it.
betterment assessment. That's a whole different thing. That becomes a betterment assessment. Like if any one of you guys want to flip the entire bill, hypothetically, and then you went to the selectmen and some people say, we don't want this, just don't want it. And the selectman says, no, you can't have it. You're kind of out. So what I'm saying is, I understand what you're saying, and you're representing what I saw myself. I will say that we did put conditions on the road. And I have some draft, which I will bring up when it's appropriate time. But we will put conditions for the road to be upgraded to a certain status. Okay.
And that would be before a building, would that work be done before a building permit is issued and written into the building permit?
Well, Naomi, is that correct? I don't want to speak for you. Is that before the CO?
It's before the certificate of occupancy because it's got traffic back and forth, but there's usually not an occupancy permit issued unless the conditions are met. Because we understand that traffic will be going in and out for all sorts of things while the construction goes on.
So I think
that's part of my problem, because if it's not opened up to two-way traffic before the building starts, it's going to be a big issue for me getting in and out. And starting to degrade the driveway that's existing there now.
I don't want to take that up right this minute because we will put conditions on it. The pleasurable thing about living on a private road, that's all a civil matter. You know what I'm saying? You bring up good points. It's not his, you going to speak on his behalf right now? Okay, go ahead, Jeremy. And just so we get this straight, are you a disapproving abutter or approving abutter, Tom?
I'm going to only disapprove if the road upgrade isn't, some type of road upgrade isn't put in place before a building permit.
Thank you. Now, Jeremy, are you going to be on the fence with him and just explain more? I just want to know where you're
He's my
at.
client. He's my client, so his position is my position. But I do want to just explain my memo a little bit. And I think you've got a very clear sense from Tom that, you know, the difficulty, the thing that makes this particular is that you have a lovely young couple that wants to invest in this town. They want to build a little house on a nice, and that's something that any town should want, right? The problem you have in your case is that you have an ordinance that really couldn't be clearer. It says you can't do that on a private road. And
that's true.
And in order to do that, a variance from that absolutely unambiguous dictate, which the town has enacted as a law.
I will grant you, you are correct. But
So,
anything in the zoning can be varianced.
right, but only
period.
under certain conditions.
Well, we'll see if we meet those conditions, those 5 points of hardship.
Right,
We're
and
not arguing that.
allow me, if I may, to speak to those 5 points of hardship. I mean, it sounds like we're, though this is technically a supportive position, I don't think you can grant the variance without board.
You said supported. Who's supporting it?
So we're in a position right now where Tom wants to support the notion of
Okay,
someone having a place there,
Okay.
but not, excuse me,
No,
not,
go ahead.
yeah, not if the town essentially conducts a taking, because that's what's going to happen here. If
We
a building
understand.
permit is issued for this property under this board's decision-making power without some kind of compensatory action with respect to the road. Tom has put literally $100,000 over the last 20 years of his money into this road. And if the town's decision tonight is that somebody else can come along and use his road that he created with money and his assets for their purposes without any compensation other than an ongoing care and maintenance obligation, which everyone recognizes these guys are willing to adhere to, then that takes his investment, my client's investment, away. That's a constitutional problem.
And so is the opposite about a taking if you don't allow the use of a property. So it's on both sides.
Well, so but that's a separate issue.
No, yeah, I understand, but it depends which side you're arguing on.
So you can impose the right conditions necessary to avoid both of those problems by creating the variance necessary to allow these folks, this lovely couple, to build a home in this location and make a family there. As long as you make this road sufficient for passability on both directions and sufficient to ensure that my client's investment is secured. That's all any private property owner would want under the circumstances. And I think that's fair.
And I understand you. I'm not saying I agree. I just say, I understand your position.
Sure.
And you ain't the first one to make this point.
And I would say, you spoke with town council about the notion of a sort of a stare decisis type of application of the prior order denying a variance. I agree with you. Generally speaking, there's usually just one bite at the apple with respect to variances. I also agree with you that the law has changed.
2010.
That's right. But if in fact, very clearly what happened in 2010 is the law made it more difficult to get a variance than it had been prior to 2010.
Well, as far as Article Prong 3, you're correct. It used to be use and area.
Yeah,
but
it eliminated those distinctions.
That went away, and 5 became multiple choice, A and B, and unnecessary hardship and unreasonable, reasonable use and unnecessary hardship becomes 5.
That's
yeah,
right.
I understand this. I
So,
guess.
but I want to make a point of necessary hardship.
Did you cover it in your letter?
I did.
Okay.
And it's part of the record, and I'm not going to reread
No, that's
my
okay.
letter like some people do.
Well,
but I
where
will
is
say,
it just for my benefit? Where would it be? You got your letter?
yes, I do.
I just want to make sure we get this right because it's your position to make. I'm not blowing you off. I really want to make sure your concerns are covered. So we're on, I don't have any page is on, which page is it on?
It's the third page under E, where it talks about literal enforcement of the provisions of the ordinance for an unnecessary hardship.
So Naomi, we can reference this conversation to that point specifically.
So when you're looking to interpret this hardship issue, what you have to do is, what the statute says is, owing to special conditions of the property itself, the conformity with the literal conformity with the ordinance would be a hardship, right? In this case, there's nothing about this property that distinguishes it from any of the properties around it. It's a basic wooded lot on a private road. There's no strange slopes. There's no soil condition that would make a hardship arise in this case. This is a basic buildable wooded lot. It happens to be by virtue of the zoning ordinance on a private road. You can't say the application of the zoning ordinance is itself a hardship. That's just not a hardship. And so while the board does have the power to grant a variance, it has to do so on the basis of some special condition of the property that distinguishes it from the properties around it. And it just doesn't exist here. And
That's
so
your
I don't
opinion.
think you can grant the variance.
Yeah,
Now,
I'm not going to
having
argue
that
the
said,
other case. I'm just saying that's your input.
that is our input.
Okay.
That having been said, your observation that, you know, this road is better down class 5 road is owing to my client's investment. And so it's only fair that if somebody else is going to take advantage of that, just as the gentleman at 18 did several years ago, he invested as well to expand the road and improve the surface at the point where his house was going to be. And so we would expect that the owners of 20, if they're developing this lot, be compelled to contribute to the development of this road sufficient to meet these needs. What I don't want is for this variance to go through kind of half measure to be put into place that ultimately leaves my client shut out. And again, the only reason this is a difficult variance case is that you have two really great young people who want to build a house here. In every other respect, this is a clear-cut denial under any normal variance request standard, because if you don't apply the variance to this property in this case, then there's no point in having an ordinance that says what this says.
I
And so
understand.
I hope that you do the for
All I can
everybody
say
involved.
is I've heard your issue. I'm offering conditions when we get to the actual motion to accept, to pass on like we did on the other one. And I have some already drawn up and I'll speak to it at that point. I understand your point, and all I can say is we typically put conditions down. And the whole purpose is life and safety access, making sure this is wide enough, the gravel surface is appropriate for heavy vehicles such as the fire truck, ambulance, police cars. And so there's some other conditions we put in. I got 5 conditions, which is typical. Some are directed by 674-41, such as, you know, we put down a signage requirement, which needs to be there because it says you got to have a sign. So is there anything else, Counselor, you want to speak to? I know you pointed out E. Is there anything else in your?
No, I'll let the rest of what I said speak for itself. I sit myself on the Hanover Zoning Board and great nights, and I really thank you for the time and attention and effort you all are putting in. Tom, you don't have anything more, do you?
Yes, I do, but I'll wait till I hear what they're.
Yeah, you got another shot at this.
Thank you,
Okay, good. Any other approving abutters or disapproving abutters? I don't think we have any. I don't think Laurie's either, nor is Eric. So at this
Did
point,
Eric Dupree get let on the meeting? He was supposed to be here tonight also.
who's this?
Eric Dupree, lot 18. He was supposed, he told me he called into Naomi.
There's an
and he
Eric
was-
Lating.
Dupree.
No, Eric Dupree had asked to be put on both of the meetings, and I sent him an invite, and I've never seen him on either of the meeting.
He had a hard time getting on the first one. By the time he got on, the meeting was over on the.
Right, and
planning
I
board.
haven't seen him tonight There was just one gentleman who was the iPad 5, as I didn't know who he was. He was sitting in the waiting room, but no one else is sitting out there. So he didn't get on tonight, Tom.
Okay, I was just curious. He told me he was going to be on tonight. I talked to him earlier today.
We want to make sure, I know this is under some tough circumstances with Zoom, but I'm being patient, making sure we don't miss somebody if they're hiding out there and we don't see them. But I don't see anybody. There's an ARIC Eric, but not an ERIC Eric. So on the waiting. So with that, proving about us, disproving about us, being none. Public at large. Anybody in public at large wish to speak? Or other boards wish to speak? Being none at this point, Jordan or Brianna, you can rebut anything you wish to speak to at this point. It's your opportunity.
Thank you, Jack. Yeah, a couple things I'd like to say. First of all, there's the claim that the road has become a private driveway, but has become a personal driveway due to work invested in it. So the road is very clearly designated as a shared right-of-way. It's designated this way in when it was initially subdivided. All of the deeds in the property reference this shared right-of-way, and it's very clear from the deeds that this is a shared road and not a private drive. This is what the deed says. Not a personal driveway. I'm sorry. This is what the deeds say. So this is what it legally is. And also this is how the road has been used. 4 lots currently share access via this road, and all of those, for whatever purposes, all those property owners have used this one right of way to access their properties. And it's been very clear that that is what this is, both legally and in practice. If we are granted the variance, as we've said under New Hampshire RSA 23181, we will contribute to the care and maintenance of the road. The reason for our variance application is that we're asking that we not be required to do extensive modifications that would make construction prohibitive. As you all know, New Hampshire town ware are facing an unprecedented housing shortage. We're looking to try to help by bringing a new housing unit into existence, as it were, and that becomes unfeasible if extensive road modifications are required. As you know, new construction is no economical feat, and it becomes untenable if extensive road modifications are required before that can even be begun. So and that's what brings us here for this variance request. Just on this notion that, so the bulk of the claims hinge on the assertion that Tom personally financed the creation of the road. So we actually went back to the seller, Lewis Page, about this. And for background, Lewis Page, the seller, I believe he's Tom's father, and both of them used to live in and jointly own Tom's home at 187 Bart Clough Road, where Tom currently resides. So the seller stated, Lewis Page stated, that he was the one who built the road in 1997. He forwarded us this information. I passed this on to Naomi. And Lewis claims that he invested significant capital into creating the road, and therefore this rebuts the claims that the road was entirely created by Tom, if Lewis's father, while they were both living there, also was contributing to it as well. Now, let me stop right here to say I'm absolutely sure that Tom has a counter response to this, but that brings up a much larger point. It appears from talking to Lewis, from hearing from Tom, from talking to the realtor, that there's been an ongoing father-son dispute between Tom and Lewis regarding the shared costs of the private drive, since they both had some share of that. And we believe that this is a civil matter between Tom and his dad. If Tom has a past grievance with his dad, if he feels he was wronged, then he should absolutely seek recourse if he feels that. But the important part is we ask that the town not allow our application to be dragged down into a family dispute that does not concern us. So legally, if we purchase the property, we will fulfill our obligation going forward. But what's happened in the past, that's a civil matter between Lewis and between Tom, and we ask that not drag down our application.
And it almost feels like Tom is trying to make money off of us. Like he wanted more money from his dad to help.
Could you speak up, please?
Oh, I
Deanna?
apologize.
Thank you.
In some ways, it feels like Tom is trying to make money off of whoever purchases this lot next.
Well, we don't want to go down that way. This is really something out of our.
We're deep in the
That's fine.
civil. The
So
civil
it
Those
woods,
are
right?
This would be a
interesting,
civil matter for a
but
civil
may
court.
not be relevant. You know, I don't want to go down. He said, she said, they said, you know, it's, that's a problem with the private road.
Sure.
to be honest.
But legally, it is a shared right of way, and we would do our part going forward. But what's been done is a sunk cost. What's been done in the past is a sunk cost, and if Lewis and Tom have something to settle, absolutely they should settle that.
So this is your last shot. You got everything?
Oh yeah, I just wanted to mention the special condition. It was mentioned that there's no special condition. So the special condition, I would say, is that in 1977, when this property was subdivided and approved by the zoning board of the day, you know, whoever, whatever that was, the idea was that all these lots were off a shared, it was basically you call it a non-conforming subdivision. So the special condition is that all the other properties are currently being used in some form, 2 with full-time residences and 1 with some kind of hybrid seasonal residence. The special condition is that, as the lawyer, as Mr. Eagleton said, there's nothing that separates this property from those properties. If they, like, we're just asking to enjoy the same use that the other properties are enjoying, in which this property was intended to enjoy when it was subdivided in 1977.
Okay, thank you, George.
That's all. Thank you for
Anna.
Thank you for hearing.
Okay, I'm going to put it out there. You can decide which one. Approving a butters or disapproving a butter? Wish to rebut anything, Tom?
Yep. Right now I'm at the disapproval of butter, I guess I would call it. The whole issue here is hearsay of anything my father said. He's never put a dime in the road. It all came out of my pocket, but that's here nor there. The acceptance of the deed is another civil matter. I think you have Lot 20's deed in front of you there. It's in the paperwork, and it specifically says the owner of the property will do road construction to the private right of way. Now, nobody's done that from Lot 20 yet. The first person, John Kendall, didn't do it. My father owned it. He didn't do it. When my father lived at my house, he didn't contribute to the road. I did all of that. Now, I understand it's a civil matter, that, but it does clearly state, rebutting Jordan's remarks, that he's getting undue burden put on him. Right from the deed, it says you will do the road construction. So this is not a burden. And the town has laws in place and regulations that you can't build on a private road unless it's upgraded proper. So that's the whole.
It's not true. That's not true. It's not true.
Well, 1711 says you can't build on a private
build.
road. Or
Oh, I thought you mean to say you can. I'm saying you can't under 1711. You cannot build on a class 6 road. That's why we're here tonight.
right. And also there's other statutes also defining the same thing. I believe it was it 36 that says the same thing, that you can't build on a private road. I understand there's a new conditional use, but just as the term says, conditional use means conditions. It's not said unconditional use. Even if this board does not grant upgrading the road, they are just going to put it into civil court that I have to bring in the other abutters to make him do the road construction and to make bad neighbors. We don't want to make bad neighbors. Jordan specifically told me prior to the conceptual board meeting, we talked in the driveway, he told me to put a deposit, and he told me if he had to upgrade that road at all, he was walking away from the project because he has no plan to ever upgrade or do construction on the road.
Again, I'm not going to divulge what, but we're going to put conditions. We heard
Thank
your
you.
concerns, and we'll see how it goes. Counselor, do you have any follow-up?
Naomi.
Oh, I'm sorry.
Hi, I just wanted to, these factual questions about who invested in the road really aren't material. I mentioned them solely for the back, what would ultimately be a takings claim by my client if the decision ends up stripping him of value, but that has nothing to do with the ordinance question before you. The ordinance question is a clear question of law, where you have an ordinance which says that they want to happen is not in this town, subject to a variance. Now, under the variance, you can only show a hardship, not because it's more expensive with the variance requirements, but because there's something about the physical characteristics of this land that make it different around it. Mr. Estrada's statement that it was the same as all the other lands around it, it just didn't have access to the private road because of the variance, is just the application of the variance. It's not a hardship for that owner. They just have to do what they're obligated to do under the terms of their deed, and then they can use the property.
Okay. Any other approving or disapproving abutters wish to speak? Other boards, public at large? At this point, I'm going to shut down the public meeting and get on to entertain a motion for prong one. And I'd ask to hold off on the second until I get this read. Go ahead, Mike.
I'll motion to accept prong one pending the recommendations you make for the conditions, Jack.
Okay. I do have it all written out. But Town of Ware Zoning Board of Adjustment conditions for case number 10-2021, private road building permit. The following are minimum conditions and requirements for variance approval for a class private road. Town of Ware zoning ordinance RSA, town of 1711. Condition 1, the applicant shall be required to post the necessary signs at the transition of a class 5 to private road in accordance with the Town of Ware sign policy and be consistent with New Hampshire RSA 674-41 on 1D private roads. Essentially, somebody comes to visit your property. We don't want anybody claiming that they didn't know it was a private road. So there's going to be an overt sign, certain size, I don't know, 3x5 or whatever it is, or 4x3. And so nobody can say when they frequent that property, coming up to drive up to see you, they run off the road, they can't sue the Town of Ware. That's part of the RSA, okay? We're just putting it in here as a condition. And here, this is the road language approved by the Town of Ware's attorney. This road has not been accepted by the Town of Ware or consists of a class. It consists of a class 5 of private road, which the Town of Ware has no duty to maintain. The town assumes no responsibility for the maintenance, including snow removal, nor liability resulting from the use of the street. Okay, so that's very clear. Second condition is the applicant shall be required to complete a Town of Ware liability disclaimer and file the liability disclaimer at the Hillsborough County Registry of Deeds and be consistent with New Hampshire RSA 674-41 1D private roads. Again, that's a 674-41 requirement. We put it in here, so we have it in one spot. 3, the applicant shall take the necessary actions to be in practical compliance with the Town of Ware's Planning Board subdivision regulation for driveway permit requirements and the Town of Ware zoning ordinance Article 36. The Town of Ware Public Works Director shall be the authority for interpreting the practical implementation of this requirement / condition. In essence, basically for driveways over 400 feet long, you need to have 12-foot all-weather surface, gravel grade. All-weather surface is an artful term that they use. needs to be 12 feet wide, and beyond that needs to be 2 feet either side. Every 400 feet, I believe it is, there needs to be a place where 2 vehicles, such as 2 fire trucks, can pass each other. It's 50 feet wide, 50 feet long, 20 feet wide. So truck 1 comes up, gets off to the side on a hard surface, and truck 2 passes it or whatever. So those are the conditions, and the radiuses and the slopes don't really come into play because you're well within the slopes and the radiuses. But essentially, the applicant will have to bring up that surface considered by the Public Works Director's opinion of what a gravel, all-weather gravel surface is, plus the extra widening out every so often, and the number of those. I think it'll probably need 2, but that's up to the gentleman who is our Public Works Director. So that takes care of the road. And I don't know if it gives you 22 feet wide if people are expecting a 22-foot wide gravel surface, but it certainly gives you 12 feet with bump outs occasionally, 50 feet long to accommodate 2 vehicles. The next one is condition 4. The applicant shall be required to take the necessary action to comply with the e-signage requirement for proper residence location identification to support emergency vehicles life and safety process. I might mention that it'd be good to do that on lot 20 in 2018 as well, because they're going to be looking for a road that doesn't exist. And what it is a marker they put out there to say private road and the lot at your driveway, at your exit of the private road, so they can identify it when they come screaming in. Number 5, in an appropriate locations, private road, implement a widening of the private road to a minimum of 20 feet, 50 feet wide. That is the section for vehicles to pass. Two emergency life safety vehicles can pass safely. Culverts may be located in appropriate locations to permit seasonal runoff associated with a private road. Appropriate gravel material shall be applied as required for a all-weather gravel surface from Barcliff Road to lot 20. That's pretty much the whole length we were talking about. Town aware, Public Works Director shall determine the practical implementation of this condition. So it's not up for discussion. That's what I'm putting on the table for, it's up for discussion with the board members, but not the public. So those are the 5 requirements, and I'll email that to you tomorrow, Naomi. The conditions that I'd like to see put on this. Okay, Mike, are you all set with that?
I am moved to accept Article 1 with the conditions that are applied.
Thank you. And can we have a second, please?
Second.
Thank you. Any discussion? Being none, all those in favor? Mark?
Aye.
Thank you. Bobby Joe?
Aye.
Mike?
Aye.
And Malcolm?
Aye.
Thank you. And myself, aye. Okay. Prong 2, please.
Move to accept Article 2.
Thank you. Second,
I second.
any discussion? Being not, all those in favor, Mark,
Aye.
Bobby Joe,
Aye.
Mike,
Aye.
Malcolm,
Aye.
and Jack. I rank that as 5. So I'm an aye, and that's 5-0-0. 3, please.
Move to accept Article 3.
Okay.
Second.
Second, thank you. Discussion, being none. All those in favor, Mark,
Aye.
and Bobby Joe,
Aye.
Mike,
Aye.
Malcolm,
Aye.
And Jack, aye. So that's 5/0/0. 4, please.
Move to accept Article 4.
Thank you. Second.
Second.
Thank you. Discussion? Hearing none. All those in favor? Mark?
Aye.
Bobby Joe?
Aye.
Mike?
Aye.
And Malcolm?
Aye.
And myself as aye. Jack, 5/0/0. And 5 as entirety, please.
Move to accept Article 5 in its entirety.
Thank you, Mike. Second, please.
Second.
Thank you, Bobby Joe. Discussion? Being none. All those in favor? Mark?
Aye.
Bobby Joe?
Aye.
Mike?
Aye.
And Malcolm?
No.
No? Okay, so, and I'm aye, so that's 4-1-0. Thank you. That one passes. Where am I? Okay, well, now I'm going to take up 18.2.1. This pertains to not having frontage on a class 5 road, the minimum frontage requirement. This is what this article is. So, call this case number 10B 2021. Keep our record straight, if you please. Okay, basically all the information on the original 1711 is here. Any questions from the board before we proceed?
Just a quick question. So this lot was subdivided prior to zoning. Is there,
Yeah, zoning was 88.
so it,
This was
would
70s.
it not be grandfathered? And
No, because the zoning trumps any requirements. See, we're not subdividing a lot, okay? We are allowing them to build on a class. In order for a building permit, you need to have frontage on a class 5, or need a variance. So that's the essence of it. The fact that it's grandfathered, it's got everything it's got. But if zoning passed after that, it gets laid on top, and this is that issue of why this, my understanding is why 18.2.1 is required. If in a more perfect world, we probably could have put both 17.11 and 18.2.1 on the same application. But because they're separate applications, we'll just call them A and B if everybody's okay with that. I just want to make sure before we start going down the process. So with that, everybody okay to accept the application? Motion?
move to accept application 10/2021B.
Which is 18.2.1. Okay, second?
Second.
Thank you. Let's see, any discussion? If not, everybody say yes. Mark?
Yeah. Aye.
Bobby Joe?
Aye.
Mike?
Aye.
Malcolm?
Aye.
And myself, Jack, yes. And so it's 5-0-0. All right. At this point, Jordan, you can, or whoever wishes to speak to it, please read Article Prong 1. Oh, you need to get your, you gotta let Jordan in and Brianna.
Thank you, Naomi. Before I begin, a question, point of order. Since my application is essentially the same for both points, I'm more than happy to read through it, but in the interest of everyone's time, would it be appropriate to carry over the previous statements because it's essentially the same? Everything I'm going to say is what I previously just said.
Well, what I want you to do is read your application.
Absolutely. All right.
Okay, because you wrote it, and the penalty of writing a long-winded explanation is you're gonna have to read it.
No, I got it.
We don't tell
All right.
people that ahead of time.
Absolutely. Point 1, the variance will not be contrary to the public interest. The primary purpose of current use lands in the rural conservation zone is to conserve and manage important habitats for the benefits of regionally or internationally significant fish and wildlife species. With our proposal, we would keep the majority of the lot in current use. Living on site would enable us to cultivate and improve the character of the conserved land by practicing on-site stewardship and good forestry practices. The subject lot is 24.4 acres, and we would only utilize a small portion, 2.4 acres, as the building lot while keeping the remaining acreage in current use to maintain the general purpose of the ordinance and the essential characteristics of the area. The proposal would not threaten the public health, safety, or welfare, or otherwise injure the public's rights, as much of the lot would remain as it is today. Granting us the ability to live on site would ensure that the property was well cared for and free of hazards to visitors or wildlife. The private drive in question is wide and well maintained with an excellent grade, easily allowing multiple emergency vehicle access. I'm sorry, 2, please describe how the spirit of the ordinance is observed. Our goal is to build a modest, discrete single-family home, ensuring minimal impact on the surrounding nature and neighborhood. This proposed use will not conflict with the general purpose of the ordinance and will not alter the essential character of the neighborhood, nor threaten the public health, safety, or welfare, or otherwise injure the public's rights. Much of the lot will remain as it is today, with nearly the entirety in current use.
Thank you. 3, please.
Please describe how substantial justice is done. While inherently rigid, there are mechanisms in zoning to allow for flexibility. We are asking for flexibility with this variance application, where the benefit of granting such a request will not be outweighed by the neighbors or general public. Granting this variance will provide benefits to the general public, including that if the variance is granted, the road maintenance will be shared with the new occupant of the dwelling, thereby benefiting other residents and visitors to abutting lots. The concept of substantial justice raises issues of fairness for the community and neighbors and are peculiar to this property, whereas other similar lots on the private drive have had the benefit of receiving building permits.
4.
4, please describe how the values of surrounding properties are not diminished. The proposed use would not diminish surrounding property values. If the variance is granted, the proposed lot would have a modest single-family dwelling constructed of not more than 2,000 square feet. The proposal would result in an overall increase in property value and tax base created by such improvements. The dwelling would be a significant distance from either of the existing homes on the private drive, as the building envelope for 185 Barclough is mostly invisible from the surrounding properties due to topography.
5, please. A.
Literal enforcement of the provisions of the ordinance would result in unnecessary hardship. The fact that the ordinance in place would restrict building and dwelling on subject lot, whereas others on the same private drive have been afforded the ability to reside and enjoy full use of their property without zoning restrictions, is an undue hardship, as the property does not have any substantial special conditions. Additionally, RSA 23181 requires all owners enjoying a common benefit from a private road to contribute equitably to the care and maintenance of that private drive. Since the owner of 185 Barclough is not permitted to reside there, the owner experiences significant hardship in fulfilling their communal obligations. If permitted a variance to build on 185 Barclough, we will be able to fulfill the owner obligation to contribute to the care and maintenance of the private drive and enjoy the benefits of land ownership that others on this drive are currently experiencing.
I, please.
As this property is on a private drive, it is currently excluded from being eligible for a building permit.
I, please.
The request to construct a modest single-family home on a 24-acre lot with good access via a private drive is reasonable. It would be unjust to deny the existing owner and prospective owners the opportunity to ever utilize their land or have such restrictions placed on them when others have been afforded the opportunity to perform construction, sales of property, and such for similar properties as we are requesting for the subject lot.
And B.
Other properties on this private drive, also without frontage, have obtained building permits, while no permit is available for the lot in question.
Continue with the owing.
Okay, and requiring the owner of, it would be impossible for the owner of 185 Barclough to have any frontage since it's on a private drive, and requiring this would make construction prohibitive to the average middle-class New Hampshire citizen, as such a requirement would significantly, there's no way to put frontage on this property. It does not have frontage. And then without a variance, the subject lot cannot be put to reasonable use. The hardship is due to circumstances unique to the property location where other buildings have been permitted on this private drive without frontage. The variance would not alter the essential characteristics of the area. The variance is a minimum necessity. Hardship is not self-created, and the current owner or previous owner did not create the need for the use variance. It is not reasonable for the current owner to use the property as restricted and eliminate undue hardship under the strict conformance of the ordinance.
Thank you. Would you at least read the question above there? You didn't read that. Owing to the special conditions indicated.
Yes, owing to the special conditions identified above, please indicate how the property cannot be reasonably used in strict conformance with the ordinance, and a variance is therefore necessary to enable reasonable use of it. And our answer follows as.
Okay, thank you. Any questions of the applicant from the board before I open it up to approving abutters and whatever else? I don't see any. Any approving abutters wish to speak to this article? Disapproving abutters wish to speak to this article? Counselor?
All I would say is the same objections apply to this particular ordinance. It's not quite as bracingly clear as the other one, but it nevertheless sets out a requirement that there be frontage on a town class 5 road or higher. And that doesn't exist in this case. And I don't believe that the variance requirements are met. I don't think there are special conditions to this property for the reasons that I articulated with respect to the other variance request, and that I restate in full for the record. So to the extent that our letter applied to 17.1.1 and 36, I'm asking that the record reflect that it be incorporated in opposition to the request for a variance from 18.2.1. And I assume that if the board goes the same way on this variance that it did on the other one, that the same conditions would apply. That would be my.
Well, the way I would say it is, you would hope the intent was we would apply the same conditions. Whether we vote yes is another issue.
Conceded.
Right, okay. I know it's late, but.
No, thank you.
Okay, so, Tom, do you have anything to say? Are you okay?
I'm here, I'm well. Can you hear
Your
me?
lawyer
I'm on?
spoke, but since you're here, I do the courtesy.
No, your conditions on on the gravel for the right of way was, the 12 feet's kind of short because what the articles I read, that kind of like for a private driveway, for a single family, not for, I'm glad you put the bump outs for the safety vehicles. That was
That's why we do the bump outs.
But it seems like 16 feet would have been a better fit for 2 cars to go by versus 12, because 2 cars can't go by 12 without bumping mirrors.
That's why you got the bump outs every 400 feet to allow that to happen.
Yeah, so somebody has to back up or whatever, you know, it becomes an issue of safety issue still.
Well, okay, I heard your point. Do
Okay,
you have
that's
anything
my
else you'd like
point.
to say? You have
I'm
anything
not
else?
going to argue about the frontage. I mean, I mean, it's not permissible by your laws, but you still have to vote on it. So I'm going to hear what you vote to.
Okay, thanks, Tom. Public at large? Other boards? Jordan, Brianna, would you like to say anything?
Yeah, just a couple things. I agree with Jeremy that this is somewhat of a cloudy issue because I don't know the full scope of the law, like what becomes a non-conforming use, what's grandfathered. But it's very clear when this was subdivided in 1977 that none of the lots had frontage at the time, and it was approved at the time. So I don't know what effect that has on today's hearing. But at the time, it was some sort of subdivision where none of the lots had frontage on Bartclough Road. And then just to the point about the 12 feet, I did actually measure. I put out my 16-foot tape measure on the road, and there actually is 16 feet of hard pack on the road. The less gravel in the middle, but it is 16 feet wide. So to Tom's point about cars being able to pass, especially with the conditions under application A, I think that's something as neighbors we should be able to handle equitably.
Thank you. Counselor, do you want to take another shot at it? approving of butters or disapproving of butters, if you wish to speak again. I just want to make sure you got the second shot.
I do.
Oh, go ahead.
I have
Tom,
one
Tom,
point.
go
Oh,
ahead,
go ahead,
Tom.
Jeremy, you go first.
No, I mean, I think in response to the notion of the non-conforming use, it really doesn't apply under these circumstances. The lot was created prior to this particular ordinance being in effect, but the is triggered in this case by the issuance of a building permit. So that's not something that exists. So it's not really that issue. And I actually don't think it's unclear. The ordinance is perfectly lucid in that sense. It's just not one declarative sentence in the same way that the other one was. Tom?
Well, I still think there's a shall in the road frontage. You just use less, you use more words to get to the 14 different types of road frontages we have. Different sizes, 50, 200, 250, whatever. Okay. Tommy, all set?
No, I got one more thing. I mean, as far as Jordan's contention that when the lots were subdivided, they were approved, it says on every one of the plats, where planning board subdivision approval not required, because back then it wasn't required.
That's correct.
So it was just somebody writing on a piece of paper and saying, this is what we got. And there was no approvals back then for these lots.
Welcome to prior to zoning.
I know.
88.
And the other
if
issue
somebody ran into the selectmen, who were the only people issuing building permits, and the select board didn't realize the 674-41 might have been on the books, they would have given them a building permit, which is probably what your lot got. So I'm just saying, timing is everything. And we're here today, and we have to deal with what we have to deal with. So, Tommy, all set, Counselor?
Yeah, I just wanted to put it in there for the record. That's the way it is.
I want to make sure everybody gets their chance. Let's see now. Public at large, other boards. I think we were on the horn twice. I think we're at a point now where we're going to ask Mike to try to articulate prong one motion.
Move to accept prong one.
And let me just briefly read through this real quick. Town aware zoning adjustment conditions for case 10. This case will be 10 B. I'll put A and B up there. 21. Private road building permit. The following minimum conditions or requirements for a variance approval of a residence on a class, a public road. Town aware zoning ordinance. In this case, it'll be 18. 2.1. Yeah, I guess I better do 2. Condition, the applicant shall be required to post the necessary signs in accordance with the transition from a class 6 to private road, accordance with the town aware sign policy, and be consistent with New Hampshire RSA 624-41, 1D, lowercase d, private roads, required sign wording. This road shall not be accepted by, this road has not been accepted by the town aware, or consists of a class 6 or private road, which the town aware has no duty to maintain. The town assumes no responsibility for maintenance, including snow removal, nor any liability resulting from the use of the street. 674-41. Condition 2. The applicant shall be required to complete a town aware liability disclaimer and file the liability disclaimer at the Hillsborough County Registry of Deeds and be consistent with New Hampshire RSA 624-41, 1D, private roads. 2, condition 3, the applicant shall take necessary actions to be in practical compliance with the town aware planning board subdivision regulations, requirements, and town aware zoning ordinance, Article 36. The town aware public works director shall be the authority for implementing the practical implementation of this requirement conditions. Okay, 4, the applicant shall be required to take the necessary action to comply with the E911 signage requirement for proper residence location location identification to support emergency vehicles for life and safety purposes. And 5, inappropriate locations on the private road, implement a widening of the private road for a minimum of 20 feet for 50 feet long. So 2 emergency life and safety vehicles can pass safely. Culverts may be located at the appropriate location to permit seasonal draining runoff associated with a private road. The appropriate gravel material shall be applied as required for an all-weather gravel surface, from Back Clough Road to Lot 20. The town aware Public Works Director shall determine the practical implementation of the condition. Second, Bobby Joe? I think she said yes.
Second.
Thank you. You didn't register on it. With that said, any discussion from the board members? With that said, being none, all those in favor, Mark,
Aye.
Bobby Joe,
Aye.
Mike,
Aye.
and Malcolm.
Aye.
Thank you. Aye for Jack, and that's 5-0. 0-0. Number 2, Mike.
Move to accept prong 2.
Thank you. Second.
Second.
Thank you, Bobby. Any discussion? Being none. All those in favor, Mark,
Aye.
Bobby,
Aye.
Mike,
Aye.
and Malcolm.
Aye.
Thank you. And Jack, 5 as aye, 5-0-0. 3, please.
Move to accept Article 3.
Thank you.
Second.
Thank you. Discussion, being none. All those in favor, Mark,
Aye.
Bobby,
Aye.
Mike,
Aye.
and our friend Malcolm.
Aye.
Thank you. 5, and I do aye. Jack. 0. Okay. 4, please.
Move to accept Article 4.
Second.
Thank you. Discussion, being none. All those in favor, Mark,
Aye.
Bobby,
Aye.
Mike,
Aye.
Malcolm,
Aye.
and Jack. Aye. 5-0-0. And 5 is in entirety, please.
Move to accept Article 5 in its entirety.
Second.
Thank you. Discussion, being none. All those in favor, Mark,
Aye.
Bobby,
Yeah, aye.
Mike,
Aye.
Malcolm.
No.
No. Okay, so it's
No.
4-1-0. Passes. Okay. That takes care of this evening's cases. So we still got some administrative stuff for approving of minutes. Thank you all. The only change that I found that I had an issue with, see if I can find it, is on page 3 at the top. The applicant is not available for May 4th zoning meeting, and comma, case continued to the June 1st meeting. So all I really want to do is get rid of the period and put case continued to the June 1st meeting. So that takes care of that. And the rest, I didn't see any problems with. You guys see any problems with it?
Nope.
We still have Tom on. I don't know who's Tom. Did they not log off? Or Laurie? So I don't know. I just
You're
wondering.
welcome to sit and listen till you're done.
Okay, well, we're damn close to being done. Okay, any other discussion on this? Motion to accept April 6 minutes?
Move to accept the April 6 minutes as amended.
Second.
Second.
Everybody moves around here on the screen. Okay, Any discussion? Being none, as amended, right, Mike?
Correct.
Okay. A second?
Second.
Thank you. No discussion. All those in favor? Mark?
Aye.
Bobby?
Aye.
Mike?
Aye.
And
Aye.
and Malcolm. So it's 5-0. Any other business before the meeting? As right now, we've only got one case for June 1st.
You got a second one.
Pardon me?
I accepted one Monday.
Oh, okay, so we got two. Well,
I have
happy
a question.
Memorial
I
Day.
do have a question. Your deadline used to be the first Monday after your meeting on Tuesday. When did you change it to Wednesday?
I never did. We never did.
Okay,
We
because
leave
the
that up.
application deadline date is for Wednesday. I don't know why.
I don't know
It was
why
always
either.
the first Monday after the first Tuesday.
I don't know. I mean, I didn't get involved in that. It's up to the administration, so.
Well, if there's been no change, I'm gonna go back to it's just,
Sure.
you know, we can make the deadline. It only makes a difference of a couple of days, but I never knew why. It was always the first Monday after the first Tuesday.
And while we're throwing things up for consideration, I really like the old cover sheet than this one, because I've got to pour through 4 or 5 pages before I figure out what the article is. You know, it used to be all on one page on the front. So, but now I got 2 pages and I got to go to page 4 before I ever get to the article. You know, so, or maybe even more than page 4. So I'd like to see if we can economize, quit killing trees unnecessarily, and see if we can get down to 1 page on the cover sheet. Should be able to. We used to be able to. So basically, what I'm saying is the very first page, and I guess it's this page called application of variance. If we just put on page 1 the articles, make it someplace. These are big fonts. You'll be able to shrink it up and put the article. And so when I read it, I can say what it is in the article, because right now I got to go backwards and find it. So
Okay.
if that's possible.
Sure. Yeah, I think things get changed to try to put them online.
Yeah, I think maybe, and I'm not being critical. I'm just saying it'll be a lot easier if we can at least do nothing other than putting the article on this first page.
Okay.
Because I can read that off and get that out of the way and not have to deal with looking around for it. And it may have been because they put the template online. Tom, did you have some question? We're kind of done for the night.
He's only his camera's on. There's no.
Oh, he's sitting in front of it.
Yeah, that's fine. There's no microphone on.
Oh, okay. I don't know. That's beyond me. I
You're
don't know.
too worried about who's left.
Well, okay. I just.
I'd like to
Now he's
adjourn
really
before
left.
tomorrow.
Now he's really left. Okay.
I think I'd like to adjourn before tomorrow.
That's probably not a bad idea. If you look at our procedures, the meeting won't go beyond 10 o'clock. I violated that this evening just to get it the hell out of the way.
Yeah.
Okay. Motion to adjourn.
Move we adjourn.
Second.
Second.
No discussion. All those in favor?
Aye.
Happy Memorial Day is all, and thank you for your support.